photos indicate that some of the photo, or some of the items in Oscar Pistorius' home rather, had been moved around by police. Well, Oscar Pistorius walked into court very confident yesterday. He always storms past the media, doesn't really look at anybody. But I can certainly say when Gerrie Nel began speaking about the WhatsApp messages and the relationship between Oscar Pistorius and Reeva Steenkamp, as indicated by those messages, he put his head down, he cried just a little bit and really showed emotion during that time. And also, really tried to converse or show some affection towards his father as well, who has been an absent figure here at the North Gauteng High Court. Of course, you would know that he has not been here. That's Hank Pistorius. He has not been at this court since the beginning of the trial. So really, Oscar Pistorius' relationship with his father has previously been in the spotlight. So to see him yesterday walk outside the court with Oscar Pistorius' sister Amy and standing with some of the family members really showed an indication that he was here to support his son. Thank you, sweetie. Huh?
I want a picture with you.
Oh, yeah.
I thought you were saying no. Flying now.
How are we going to take it?
No, not with you.
Yes.
Do you think you reporting?
Uh-huh.
I want him to stand there, take a picture that I'm gonna.
Oh, it's beautiful.
I want to off-see.
Oh, good.
Rub it in.
Ufuna ukuba sesithombeni.
Yeah, he wants this question. The monitor, camera, Crisalda, na, ona melada, rakoba.
Hey, ungawe baba. Yo.
Wena ubatla ngipisa.
Umunna. Anorko, ona sheteso. Obona. Kiyenza kuthisa. Wema yiso. Si, vama moteli. Obrisa right again.
Yeah.
Ona ngikemika. Monga sitelle. Or but check yourself. Can we use it?
Yeah, of course.
Yeah. Maro ulimo kodi. We're coming to the Crisalda. Switch on this also.
Marako balance again.
La left, man. Can't you better tell it anyway? Namela before you can see it.
Yeah, get total.
Mara angle ki batang ka si kreyam.
Eh?
Angle ki batang. Tako bonsor ki tara.
No, why is it guy 1 o'clock? No. Hey guys, be careful, yo.
Because I will forget. Oh, very simple.
Is it not locked already?
What's happy? Umtel channelin.
Hey, Uskawa Papa, please, eh?
There we go. Hurry. Crisalda, reporter.
Oscar Pistorius is back in court this morning. We're getting a lot closer to the verdict in this trial. And Oscar Pistorius basically saying that he didn't shoot and kill Reeva Steenkamp on purpose. It was all a mistake when he shot and killed her. It was all a mistake when he shot and killed her. Well, Oscar Pistorius says he was not able to. Well, this vendor boy is looking for pictures at this time. He says that those pictures should be taken for his WhatsApp profile and that... Someone help us. Susango.
Rihanna ko ma'am. Rihanna ko ma'am. Kawai.
APC 1 e tla ba
Okay, I'll be around anyway.
Then Mr. Nel made the submission yesterday. This conspiracy. The police would have moved the fan. The police would have moved the duvet. How would they have known? Where is this conspiracy? And I said yesterday, I submitted to you, my lady, that that's not the case. We do not say it was a conspiracy. We simply say that they must have inadvertently moved because they would not and could not have appreciated at the time the importance of the fans and the duvets. So we're not alleging a conspiracy. And that's why we took you to the evidence of Colonel van Rensburg, who had no difficulty to walk through the door that would have been blocked by the fan. No difficulty. Shows one thing, the fan was not at that time early in the morning in the door. And it makes sense, because where the fan was positioned, if you think back of photo 55, there's a small space between the radio and the bed. It was there. So you had to move it to get out, there, to work there, to open a duvet, to pick up the duvet to see if there's blood splatter on the carpet. They've done it. I will show you two places where they picked up a carpet, where they picked up a towel, to look for blood splatter, to look for telephones. So they did that. I'm not necessarily saying that's wrong, but what I'm saying, then don't come to court and protest an undisturbed scene and then cross-examine the accused as if that was the scene. Now, my lady, it's not only me saying that. It was not only our submission yesterday. Page 1551 of the record and 1552. The accused evidence. Maybe if I may ask Warrant Officer van Staden, he hasn't got a cable. It's 1551 right at the bottom. 1551. It says, the question, so a policeman moved the fan to there, or somebody moved the fan to there, knowing that your evidence will be that the fan was in the door. That's the answer. I do not think that the police or anyone knew what my version was at the time of taking these photos, my lady. And then the next page, 1552. Of 1552. Why would they move it then? My lady, they probably moved the fan so that they could spread out. If you look at other photos where they spread out the duvet, they had to move things. So at no point when they were busy with Hilton Botha's investigation until the point that I tendered my statement and during the bail, did they know my version. So I'm not saying that they deliberately moved the fan because they did not know the fan was part of where the accident happened. But the fan was moved. I did not place it there. From the accused said, but I'm not making that accusation. I'm simply saying they could not have known at the time. And that's where the difficulty came in, where the state was saying, but I'm not there to play a chess game against myself. We say, no. It's not a chess game against yourself. You call a Colonel van Rensburg to say no one else went up in that crucial time. You say he was with Botha. We challenge you all along to call Botha because we say Botha, and I'm going to show you what he did to the accused in the bail application. Botha must come and tell us what his views of the bedroom. Many challenges ignored. He was number 76 on the witness list, but he's not called. Van Staden then tried to assist Colonel van Rensburg. Says, I was the only one there. My lady, I'm going to show you his evidence, verbatim, where we pointed out and say, but who's that hand between 6 and 7 at 6:07? Colonel Motta's photographs. Yeah, I don't remember them being there. And more, I'll come to that. How can't you remember if someone is there, if your previous evidence was, I'm definitely alone, there was no one. And I'm going to take you through his evidence where he sort of absolutely considered, well, it was not the truth. In different language, but I'll show you. Yeah, I see now the photos and I understand what you say to me. Now, it is in that respect that we say, how can you say you're not supposed to play a chess game against yourself? That's not what it was all about. We refer to Sergeant Sabeta's affidavit read in court to Colonel van Rensburg. We ask him, Colonel, what is a A1 statement? He says that's generally the first man on the scene. He makes the first statement. I said to him, but Colonel, how's it possible that he tells us? He says he was there. He says that Botha subsequently arrived. He says he was upstairs. How can he speak about in his statement about the silver pistol in the bathroom and so on and so on? His answer, not, all right, accept he was there. No, it must be hearsay. It must be hearsay. And that's it. And he moved on. It cannot be. It was not only his statement. We asked him, what about statement A, statement B, statement C, statement D? All police officials saying, we were there, upstairs. What about it? No, it's not so. We asked Warrant Officer van Staden, who was Colonel Mafokeng? I'll give you the right name, my lady. And Colonel Mota, no, he's commander. They were there. He stopped denying that. Not called. Now, if you want, as the state, if you want to claim that the scene was undisturbed, you must bear in mind that as part of circumstantial evidence and having to prove your case on that basis, you must exclude other reasonable possibilities. You can't just protest it and he says, yeah, but you did not put that and that an issue. We pointed out to Colonel van Rensburg that he's not telling the truth. We pointed out that he made a first statement pretending that he was alone. And then suddenly said, no, he was with Botha and he couldn't explain it. We pointed out the discrepancy with the cell phones. We pointed out, how did you see a cricket bat in your statement with the names on top, whilst on the photo it's the other side, way down? And he said, well, when he made his statement, it was knowing all the facts. It's not so. That didn't come out of his statement. Now, it's in view of that. And, of course, Mr. van Rensburg moving through the sliding doors without the blocked fan. The state cannot avoid that. So the difficulty with the state is, what must the court find now in view of the evidence that we've just presented to you, the cold facts? What must the court say? The only reasonable inference, excluding all other inferences, is this, that the scene was undisturbed? It cannot be. On their own evidence, it cannot be. So what must the court do? The failure of the state to present the other evidence leaves that one big question mark and a second and a third. And now the court must be as bold to say, well, I'm going to ignore that. I'm going to ignore that he could have moved out of the door that was blocked by the fan. I'm going to ignore that he didn't even know that the fan was turning, so the fan was not there right in the door. I'm going to ignore that and find that the scene was undisturbed. I'm going to ignore when Van Rensburg said, photo 5 depicted what's on the photo, only to say in cross-examination, well, I did not see everything. I observed some of the smaller and some of the bigger things, and my observance is average. Not good, it's average. What must the court do with that? Ignore everything and then be as bold as this, as the state requests, to say, I find now, because that ultimately, with respect, my lady and learned assessors, is the finding that you must make. I find that the only reasonable inference, excluding all other inferences, is that the scene was as per photo 55. I'm going to ignore photo 00. I'm going to ignore the photo with the scene stretching, the electrical cord reaching. My lady, just as a house to get the house in order, we will mark that photo as an exhibit and make it available to you. There's no dispute, it was made available by the state, just to give an official exhibit number. So that's the difficulty with the state's case, and the failure to call the evidence just serves to compromise that even more. My lady, then on a point of law, Mr. Nel spoke, and I'm jumping, but I will deal with that, but it's just to address some of the points made by him that I say was that were materially wrong. And it is this. He says that perception of the accused, the perception that was intruders, must be reasonable. My lady, that's not the law. What the law is really, when someone is charged with an offence requiring intent, you test intention with the subjective mind. It's subjective, not objective. What you can and should do, you can look at probabilities and you can look at objective facts to determine whether he's telling the truth about his perception. But that does not change the requisite that the perception is subjective. What the real effect of the law is, once you find that that was genuinely his perception, but he was negligent in the following respects, then you're in the arena of culpable homicide, and this is made quite clear by all the authoritative textbook writers. Then you move to the next step and to say, well, I'll give you the benefit of the doubt in your perception, but that's not the end of the case. That is what you subjectively thought at the time, and I accept it because that's not only what you said it immediately after the case, immediately after the incident. You told Stander within 4 minutes. You told the police. You told Gerrie Stander. You told Johan Stander. You told Dr. Stipp. He repeated that. He went into the bail application without seeing the docket, without hearing the evidence of the investigating officer at the bail. Before that, he filed his affidavit telling his story. So it can't be a recent fabrication. He did it then already, before being exposed to the statements, to the docket, and to any evidence. So on what basis do you say that he's lying about it? Whether he was negligent, that we will deal with. And that falls within the ambit of culpable homicide, which is a very different argument. And I may say so, I really genuinely believe that's where the trial should have started. And that's what the trial should have been about. But unfortunately, it was not. Mr. Nel spoke about Professor Derman, and he calls him a self-proclaimed expert. That's extremely unfair. He's highly, highly, highly qualified. He is the most qualified person in the country. Whatever he was saying to the court, he backed up with research, with authoritative articles, publications, on that very point. He was not saying something because he said, that's what I'm thinking. He says, what I'm saying to you is also in research. But it's more than that. Then Mr. Nel says to you, and you know, how can you depend on someone's evidence where his memory was fuzzy? He did not say his evidence was fuzzy. He says it was a bit fuzzy on the reaction to the second startle. He couldn't remember it. What was his reaction to the second startle? Because that was not as important. His evidence was not fuzzy in general. And in any event, not fuzzy, but he says, on that, I'm a bit fuzzy. He explains, he says, I just cannot remember it. I'm thinking back, and blame him for not keeping notes. That I understand. But that does not mean that he's not highly qualified and that he was not absolutely, whatever he was saying to the court, was corroborated by research. But what's more important, then he gets blamed. He says, where's that part? He gets blamed and says, you, come and tell us you're an expert. Why did you not investigate that third startle? This magazine rack, why did you not investigate it? My lady, I want you to take you to the evidence of Professor Derman in that respect at 2914. Right at the bottom, where he says, I've asked you a question. Now we get to the third startle and it goes to 2195. There was a third noise, which evidently is the noise of a magazine rack. Evidently because I do not know what is it. And he carries on, and without wasting time, the other place is 2870, my lady, and 2571, if you would make a note. I don't want to waste time. But what he says there, he says, I did not investigate the sound. What must he do? Must he now go to the house, take the magazine rack and move it around? He's an expert. He says, this is the version. The accused heard this noise. It's subsequently, according to the accused, he thought it was the door opening, but it turned out that he believed it must have been the magazine rack moving. That's an inference. He says, that's what I know. What must I investigate? All I can say in my expertise, that if you have that noise in that situation, that can create, and in my view, created the startle, and I will deal with it later on. So by blaming him for not being an expert because he did not do an independent investigation into that, experts don't do that. Unless you're a ballistic expert. You go out to the scene, but psychiatrists, psychologists, medical people, they say, if this is the version, and it's for the court to accept or reject. That's what I say on the version. So how can he be blamed for not going to and doing an independent investigation? The other point made by Mr. Nel, he says, look at that grouping. Look at that grouping on the door. It's a good grouping. Lady, what he should say to you, and I'm not a shot. I haven't touched a firearm for many, many, many years. But if you put me 2 meters from a door and ask me to fire 4 shots, I'm pretty sure I can get a better grouping. If you say to me, aim, and fire from 2 meters, my lady, it's from here where Miss Johnson is sitting, there. Fire 4 shots in the door. We must be careful when we look at that grouping and think that's a person 100 to 150 meters away. Then it's a brilliant grouping. But 2 meters away. Is that a good grouping for 2 meters away? That's the only thing that I want to highlight. So we must be careful not to be sidetracked by good groupings and forgetting that it was 2 meters. And whilst I'm dealing with this point, Mr. Nel kept on submitting that the accused was in the bathroom when he fired the shots, discharged. He was not. He was standing at the entrance. And Captain Mangena agreed in cross-examination. He said, yes, his position at the entrance is more consistent. He says there's a primary residue at the light switch at the entrance, and 2 of the cartridges would explain him, one in the passage and one in the entrance to the bathroom. It would, if you look at that and you look at the primary residue, the gas is expelled by discharge of the shot, and it's on the propellant, and it's on that light switch. It tells me that it's more consistent that he was in that position. So, and that goes deeper and deeper, because what does that do to Mr. Nel's submission that the accused was standing in front of the door, toilet door, talking to the deceased. Therefore, she was not scared. She was not hiding. Forget about Mr. Johnson's, Mrs. Berger's evidence of this terrified, petrified screams, blood curdling. That cannot be reconciled with this. The accused was not standing in front door. Why, if he wanted to shoot someone in an argument, would he remain in the entrance as if he's scared? of whoever was in the toilet. That's far more consistent, that he was scared, that he did not trust whoever was in the toilet. Otherwise, yes, walk into the bathroom, stand right in front of the door. That, they said at the bail application, and I'm coming to that. Bertha was quick to say that, and to say it was 1.5 meters from the door. And Captain Mangena, when I asked him, he says, I don't know where he got that from. I don't know. I asked him, I said, where did he get that from? His answer is, I really don't know. But I'll come to that, my lady. Then Mr. Nel, I don't know the correct answer, but he was bold enough to make the submission. He says, on an analysis of everything, I submit to the court that he never activated the alarm. That explains for his uncertainty in his evidence. He never activated the alarm that evening. That was his submission to you yesterday. It's also in the heads. But then, when it suited him, he changed the story. He says, and don't believe that the deceased could have gone down to eat at a later stage, because then she had to deactivate the alarm. Now, was the alarm now on his case on, or was it off? When it suited him, it was off. When it suited him later to dispel a position, the possibility, then he turns it on again. It cannot be. You have to be consistent in your approach. My lady, his submission to you on the relationship, I'm not talking about what you, and I fully agree, because that's what we also say, and he says, be careful what you read in WhatsApp messages between young people and even between older people. Only we don't know how to send WhatsApps, but that's not important. My lady, he says the following to you. He says there was a 27 January, that sometimes I'm scared of you, 27 January. Then he says on 7th February, she was upset because he raised his voice, because they did not leave immediately. You know what he submitted then? He said, and that relationship, that unhappiness, did not improve. I was in an unfortunate position when I drove back to switch on the radio, and that specific clip reminded me of his evidence. It did not improve. Is that true, my lady? I just ask you, go and look at every single WhatsApp message after 7th February. You see how quickly they made up, how it was lovey again and kisses and whatever pet names, and missing you and crosses. Immediately after that, up to the fatal time. Now, on what basis did the state make that submission that after 7th February, that unhappiness, that relationship, that unhappy relationship, which is not true, did not improve? Where's that evidence? He blames the accused. He says, this call to Peter Baba, Mr. Baba, the security man. I thought he was quite entertaining in the box, my lady, but so be it. He says, Mr. Baba said, he's fine, or everything is fine. There was a confusion what he was really saying. If he was truthful, why not ask him to call the police? Is the correct submission not? But my lady, I must however accept, by that time, 3 things had happened. 1, he'd already phoned Mr. Stander. 2, he'd already phoned 911, which is far more crucial than the police, because he wanted to save her life. And 3, he was crying. He was crying. When Mr. Baba spoke to him, he was crying. And I think that should rather have been part of the submission. And then you can say, well, maybe in those circumstances we might have expected him also to say, please phone the police. He's reported this already to someone that he could trust. My lady, and this last aspect that he dealt with, we will fully deal with. But maybe just to address a misconception of the defense. He says that the accused in fact, contradicted himself and raised 3 versions. Now, I don't know what the 3 would be. But then he says this criminal capacity, and then claiming putative self-defense. It's inconsistent. It's like saying I was not there, alibi, and then say, well, if you found I was there, I acted in self-defense. Well, lady, may I explain it? We deal with it in detail in our heads. But just to address it at this point in time, we're not making the submission that the accused did not arm himself. He armed himself. He went to the toilet. He foresaw that it might be necessary to fire a shot. He looked at that toilet door. He was anxious. He was fearful. He foresaw that if necessary, he could fire. We're not saying that's not so. That's quite clear. Where Professor Derman came in, first of all, to explain to you why the accused on his stumps in that vulnerable physical state would go to the toilet. He explained, and that was not challenged, and that was also in the report of Professor Scholes. To say that's what you get, that is the result of disability. Professor Hunt, in his book on the general principles, talks about, in relation to abuse on women, of that slow burn effect. You can't look at the last reaction when a woman picks up, and I'm not talking here about exculpating or mitigating. I'm talking about a principle where he explains so well to say that that day when she pulled the trigger and killed the abusive husband, you can't isolate that. You have to look at the slow, use the word slow burn, effect of that abuse over time. And then you consider whether it's excused, it's exculpating, or whether it's mitigating. But please don't look at it in isolation. And that's what we will say to the court at the end of the day, and the learned assessors. You have the facts, but please don't say that it's contradictory, the offences, the putative and the startle. Because what we then say, now, and I apologize in advance what I'm going to do now, my lady. Now you're standing at that door. You're vulnerable. You have the effects of the slow burn over many years. You're anxious. You're trained as an athlete to react to sound. Sprinters. We all know him. You're trained. He says, take all those factors into account. And he stands now with his finger ready to fire if necessary. And he stands there, and then I made the noise louder. Now, 2 things can happen. If I stand behind someone with his finger on that trigger, and he's in a fearful state, and I clap my hands behind him, I'm very happy to make the submission that in some instances a person will fire, reflexive, in some instances not. That's all Professor Derman was saying. He says, and he explains the hypothalamus. He explains the amygdala. He explains that it's not something that is grasping from somewhere. He says that is your primal instinct. He explained when a woman attacked a polar bear to save a child. He explains when you see something and you freeze. You don't say, excuse me, I am now going to freeze for 5 seconds or 10 or 1 second. You don't do it, it is reflexive. He just explains to us where that reflexive conduct comes from. And then he says, I cannot tell you how long it would last, because what happens instantaneously And sort of simultaneously, there's less blood flow to the brain and more to the primal instincts to get the body ready. That freeze, that reflexive, and that's all that it is. It's no magic potion. And all we say to the court, when you consider this, my lady and learned assessors, you have to interpret his evidence and say, it's not two versions. I accept he armed himself, ready to shoot, when necessary would shoot. He's fearful, he's vulnerable, he's got a history. Because that's the common cause evidence, not common cause, not challenged. State did not call someone to say, Professor Scholes, you don't know what you're talking about. Professor Derman, you don't know what you're talking about. He sat with the psychiatrist, Dr. Kotzer, in court. Why did he not call her to say, it's nonsense? It is nonsense. Why did he not put to Professor Derman? But Professor Derman, Dr. Scholes is sitting here next to me. What you're saying is absurd. He couldn't. So it's there. It's not challenged. And in the case of Professor Derman, it's supported by publications. And is supported by Professor Scholes. Independent, appointed by the court on behalf of the state. You didn't see him, I don't know him. That supported that aspect. Now, what you must do, and I'm very glad to say that you must do it, not us, my lady. We can only give you the information, is to say, when he heard that sound, in his vulnerable state, having regard to the slow burn, having regard to the anxiety, having regard to his reaction to sound as an athlete, was that shot reflexive alone, or was it a reflexive shot combined with a cognitive thought process? If it's the first finding, then he lacks criminal capacity, because you have the two legs, the cognitive and the conative. The cognitive is where you can distinguish between right and wrong, and the conative you can, but you can't act accordingly. You know it's wrong to shoot, you know it's not right to shoot, but you shoot. You don't have, for whatever reason, in this case reflexive, the ability then to act in accordance with your knowledge of right and wrong. You have to decide on the facts and looking at his evidence, and we deal with it in detail. We give you every portion of his evidence in why he fired a shot. And you would see, he's trying to explain it, but the accused wouldn't know. The accused had no clue about the startle. He had no clue about the working of the amygdala. He can't say it. He can just tell you what happened to him. If your finding is that it was purely reflexive, then he lacked capacity. If your finding is it was reflexive but also thought process, then your finding must be that that there was capacity, but then cannot ignore the reason for the shot. And that's all we were saying. Then you have to look at a putative private defense. Or is the case of the state that, and it is, that he went there to kill the deceased? If that's the finding, you can take a red pen and draw a line through my heads of argument, but we will show you why it's not. But the moment you accept his version that he thought there was an intruder, the one that was not fabricated, that came right from the beginning, that moment you're confronted with that issue, my lady. And the law is not difficult. It is just to make your finding. If you find it's purely reflexive, then we know it's a startled and exaggerated fight response, and it's reflexive. If you're finding it combined, it was not only reflexive, but it combined with the thought process, then you must say, what was that thought process? You cannot ignore it. And that thought process is, oh, they're coming out. I must protect us. That's what putative self-defense is, that you believe that you're in danger, that you believe that you can shoot. That's exactly what it is. And that perception, contrary to what the state was saying, does not have to be reasonable. You can take objective facts and probabilities to test if he's lying to you, Did he really hear a window opening? Or was he simply chasing the deceased? That's a different fact find. But the moment you find that you cannot reject his version, that he thought it was an intruder, that moment you find yourself within the set of facts. And then to say, well, I don't find it's reflexive, there must have been thought process as well, assuming that's your finding. Then you must ask, what was that thought process? And you see it in his evidence. He was fearful, he thought he heard the noise and he associated with someone coming out. So how can it be conflicting? How can you say this is akin to an alibi, I'm not there, and a self-defense? It's not. It depends on the interpretation. Only in that respect. So it's not that difficult, my lady. So we say with that in mind, my lady, and unfortunately in this process I've summed up to a large extent many of the submissions later in the heads, but I will then start to deal with the heads.
Before you move on, I didn't want to interrupt you. You spoke about the slow burn. I understand it when you speak about an abused woman situation. How does it apply to the accused in this case?
I'll explain that. That's fully dealt with in the evidence of Professor Dermot, but I'm going to sum it up and also refer to, you're a little boy without legs. You experience daily that disability and the effect of this. You experience daily that you cannot run away. I'm not talking about abuse here. You know, I cannot run away. I cannot run away. I don't have a flight response. We all know that we have three responses: freeze, fight, and flight, primal. What Professor Dermot was at pains to explain is to say that is well known in research, and he's also his experience. With that disability, over time, you get an exaggerated fight response. That's why he would go and not run away. That's the slow burn effect, not abuse. It was just a brilliant, the word was for the first time used in relation to abuse. So that constant reminder, I do not have legs. I cannot run away. I am not the same. That's with him. He can pretend. He can pretend that it's fine. And is wonderful with his legs on. And we see this athlete. And that's what Professor Scholes was saying. And I will invite you to look at that part. When you say we have two Oscars. And that's why I made that submission yesterday, my lady. To say we must understand that slow burn and the anxiety. If you're anxious and if you're vulnerable and if you have the slow burn effect, you don't go to bed and can't sleep. Lie awake. But the moment you confront it with danger or perceived danger, it comes to the fore. Then you are compromised because of the slow burn, because of the anxiety, because of your real position. In that sense. And it was in that sense that I say the abuse is different, but it's the same. Without legs, abuse, abuse, abuse. So ultimately, when that woman picks up that firearm, we can use the common word, I've had enough. I'm not shooting you because you have just assaulted me. Not because of one punch with the fist in my face. I would never have shot you because of one punch with the fist in my face. But if you've done it 60, 70 times, that effect of that over time, it filled the cup to the brim. That's in that sense, my lady. It caused one thing in him. When he gets that startled response instantaneously, or as sort of instantaneously, gives rise to three responses: fight, freeze, or flight. And he says that fight one is now exaggerated because over time it develops and the other one disappears because there is no flight in your primal brain. That's the cause of the amygdala. I hope that explains it, my lady. Thank you, my lady. Now, my lady, it's Exhibit D. I'm going to read it to you and I'll give you the page number. It's pages 26 and 28 of the bail. Record. I will read it to you. What the state did to this accused, and they want this accused then to come into this trial and not to be apprehensive. They told him that he committed a premeditated murder. He stands there in the magistrate's court 3-4 days after this traumatic experience, and then he hears the following. He hears that he was standing. No, before that, he hears the following. I read. This is the summing up, the argument by Mr. Nel, page 27. So, what does the objective facts? What did he do? He got up from a bed, put on his prosthesis, armed himself, walked 7 meters. It's not a wake up, there's somebody standing in front of, I think it's a robber. He goes on, page 28. Now that is clear. I walk into a bathroom. There's a toilet door and I shoot. I want to kill. That's it. The door is closed. There's no doubt about it. I walk 7 meters. I see a closed door. I shoot. That's all. That's the cold facts. Then he gets Mr. Botha to come and say, to come and give evidence. And he says, the facts will be that he put on his prosthesis. He went to the bathroom. He stood 1.5 meters in front of the door in cold blood, shot him. And he says at page 167, when he was asked, where do you get this from? He says, because I spoke to the forensic experts after they reconstructed the scene. And they explained how it should have, how it did go down. And then we decided it must change. I must now oppose bail. Because he was asked, but what caused you in the beginning? You said you would not oppose bail. Why now? He says, no, it's serious. And I spoke to the forensic experts. I asked Captain Mangena, where did he get this from? Because Captain Mangena says, I cannot say to you. He could have been 60 meters from the door, and he could have been at the entrance. And when we spoke to him about the primary issue, he says, yes, it's more consistent that he was the entrance to the door. And yes, he was on his stumps, which shows in itself a hurried movement. On his stumps. Now, you bring that accused, and with that, you get a finding and a bail that it's premeditated murder. And you bring him to this court, and you think with respect. The accused is not apprehensive, and that explains why in the bail application, we said, my lady, please bring that man. Bring Botha. We need to put this in context before you. What the state was doing to the accused. Because it was plainly false facts. I may say to you as a matter of interest, to show you the quality of Mr. Botha, the bail application, at page 147, when he was confronted. 148. He had a very different story. He still stuck to his 1.5 meters somehow, and somehow to the prosthesis. But then he says, and I asked him, I say, but forensically, I took him through a number of factors. I say, and we know now that you indicated that ballistically and forensically what you saw at the scene could be described as consistent with his version. He had then to concede. That would not make you to oppose the applicant. He says, this is actually an unfair question because I can't say what ballistics hasn't told me anything. What? He says, I'm sorry, I can't say exactly what. Ballistics hasn't told me anything yet. Forensic hasn't told me anything yet. I stand here without any specialist statements. Wow, my lady. I've read you the other one, where he said he was saying it because of ballistic forensic input. Now, that's the problem, and we say there's your number 76 on the list. We need to expose this to the court, to expose the submissions made to you. And then when you consider the accused in the witness box, was he many times argumentative? Yes, my lady. Should he have been? Absolutely not. Absolutely not. But please see that those questions were coming from the same person that put cold facts before the court, that he put on his legs, walked to the bathroom, stood in front of the door in cold blood shot, which we know are not the true facts. So, of course, he's 26, 27 years old. He's standing there. He would be apprehensive. And I'm not trying to justify when you start to be argumentative, but I'm asking the court, as part of your assessment of the accused, please also take that into consideration. My lady, and I mean well, I'm going to read it to you. The heads of argument. Paragraph 171. Now, Mr. Nel, I have a lot of respect. I put it on record for him. And his experience. But can I read to you what he's doing? And I say he's doing this because he's desperate. I've already said he just ignores the first shots. He ignores the cricket bat. He ignores the neighbours. He ignores Mrs. van der Merwe saying, I heard the screaming. I thought it was a woman. My husband said, no. That's the accused. You won't find it in his head. Let's ignore it. And he says then, and it's a point that I need to address, he says, look at Saul's case. You can't take every inference and measure it if it's the only inference. He says, the mosaic. What he's saying to you, in fact, I can have a little bit of a insinuation that it could be. There could be an argument. There could be eating. There could be that. Combine all the could be's and it's then a fact. That's not how it works. I understand that you look at evidence in context. Everything. Of course it must be like that. But you have to test inferences. You have to say, can I draw that inference? And in asking myself the question, is that the only inference on that aspect? Is that supported by the proven facts or not? Otherwise, you find yourself to take 7 possibilities, combine them and make them a fact. Make them a conclusion. That cannot happen. But to get back to 171, my lady, look what he's doing. The defense has and will again argue that 90% of all the messages were of a loving nature. And then listen to this, my lady. But we can do no better than to quote Mr. Carr, sometimes referred to as Dr. Carr, I don't know the man. A clinical psychologist. Radio Jacaranda. I was tempted to say 2014, Volume 1, SA Criminal Reports. Or where is that? Mr. Nel knows. He cannot do this, my lady. You cannot quote a radio and say this is evidence. That's naughty. We used a clip of a loving relationship, and the court correctly allowed it provisionally and asked us for argument, and we deal with the argument on real evidence and why it's admissible. That's the way to go about it. What does this do in the heads of argument? It can only find its way when you know the holes are so deep that I have to plug them with inadmissible submissions. And that this is symptomatic. It's so wrong. I never expected this. And I thought when he was going to address the court, he would at least take that out and say, my lady, I cannot have the law report Jacaranda 94.7. He left it there. And that tells you something. That tells you something. That the hole is too deep. He had to resort to a radio station. My lady, I'm with your approval, unless you direct otherwise, I'm going to be very short with counts 2 to 4. Very short. We've made our submissions in the heads of argument. I'm going to sum up in 2-3 minutes the crucial points, and the only reason I sum up to give the court the benefit of our submission, but it's in the heads, and I would ask the court, and I know the court read the heads because I picked up the reference to the animus. So I'm not going to do that, but may I make limited submission? The first one is, there was a Kanyapa case in 1979, we referred to it, where the Supreme Court of Appeal at that time, the appellate division, found that you can take a conviction into account on one charge as proof for another. That was so wrong, and ultimately, in Bruin's case, it's in the heads, the appellate division overruled its own decision to say it cannot be. You cannot do that. You cannot do that. What the state was clearly doing was to go and fetch cases from another jurisdiction to bring it here in the interest of justice. It was not in the interest of justice. It was to create this atmosphere, knowing the deficiencies in the murder trial, knowing the deficiencies of premeditated murder. So what am I going to do? I'm going to get cases from another jurisdiction, put it there and say, I want you now to use those findings as facts to convict him, additional facts. You cannot. The Bruins case is there in the AD saying you cannot do that. If I go to count 2, my lady, count 2 is the sunroof incident. We deal with everything. But what I ask you, and the learned assessors, when you consider that, please first consider Mr. Fresco. Don't look at him only in the context of count 2. Also look at him in the context of count 3. He contradicted himself so many times. And the epitome of his evidence was in re-examination. When he came to this court and he took a photo of a speedometer of 260, and he says, just by the way, my lady, that was the accused. And we said to him, excuse me? Just look at the time on that photo. You were driving. Oh, okay, then it was me. He was out to incriminate the accused because he was an accessory accomplice. He was an accomplice. He made a 204 statement seeking indemnity. And we know the dangers. We know the dangers. And it came out also. He was assisted by Mr. Witz and Mr. Clifford Alexander, an attorney. Mr. Witz's experience. My lady, when you look at that 204 statement that was handed in, you know what I don't find? I don't find that the accused asked me to take the blame, because that would be defeating the ends of justice. And when you ask for the 204, you say, I ask a 204 on account of the following offences. It's not there. And when he started his evidence, it was also not there, and later on he introduced the blame. And then when he was asked, now when was he asked, when did he ask you and why did he ask you for his blame? He was all over the place. He was all over the place with his ticket. Why he was stopped. The crumpling of the ticket, he never took the court in his confidence. In evidence in chief, he took the police to the place where the shooting happened, only for us to find out that they had to drive 4 times past it. He was just not only a poor witness, he had an agenda. Ms. Taylor, the accused, she says, the fact that it's not true is important. He cheated on me with the deceased. She's got a motive. She contradicted herself many times. Let's forget about it. Let's look at that sunroof incident. There are at least 3 things that you want to be consistent. It's the time when it happened, more or less. It is divergent, far apart in time. One about 5 minutes after being stopped, then 10 minutes. One long after we'd gone to another house. So time is gone. Place, totally gone. It's not good enough to say, I don't know. At least give us some description. Totally contradictory. 3, the reason for the shot. Totally contradictory. She says Fresco and the accused, decided to shoot at the robot. And they laughed. Fresco said, that's not so. So on all 3 material aspects, all they agree on is shot through the sunroof. Now that's easy to do. That's a cold fact. But you have to look at the surrounding facts. So they materially contradictory on every aspect leading to that. But that, and then afterwards, again. Now, was he going to the airport? Was he going to eat? Was he going to Athol? Was he going home? Absolutely contradictory. And we say, if you just apply the law, there are big question mark. And it's not only reasonable doubt, there's huge doubt. But we refer to the cases, but at the very minimum, with the poor quality of the evidence and the serious contradictions, there must at the very minimum be reasonable doubt. But we deal with that. This 3rd count, my lady, that's that he discharged the shot. My lady, the 3 things could have happened. 1, he pulled the trigger. 2, in the process, his finger made contact with the trigger and exerted the pressure. And thirdly, that the firearm was not mechanically sound. Captain Mangena did not test that firearm. Let's start there. He spoke about the Glock in general. But it's also not too important. Mr. Fresco didn't tell us when last this gun was tested. We know a Glock should not and cannot go off without pulling the trigger if it's functioning. We don't know if it's a problem. And we know in every case, at least where I was involved in, where there was a firearm, the ballistics would take that firearm and test it. Why did they not do it? Why not? I don't know. But that's not important view of what we submit to you. I've referred to his evidence yesterday of not him, Mr. Lerena saying, accused said to me, I don't know what happened. The shot went off. I don't know what happened. We say that doesn't help him because he was negligent. He should never have handled that firearm. C is in fact better, but it also fits into sub B.
You should never have handled it, or you should never have asked for it.
Never have asked for it,
yes.
Never have used it in the sense that he made it safe. He should not have done it. And he says that, my lady. He says, I'm sorry, I made a mistake. I should never have asked for it. I should never have made it safe. I should have looked to see if there was a magazine in it. So he's not, as the state's saying, avoiding blame. He says that. All he says, really, I did not deliberately pull the trigger.
So what is the finding that this court should make?
He's guilty, my lady. He's guilty on the first alternative. That he negligently used that firearm and causing the discharge. Must be like that. He says that in so many words. He says, I made a mistake. We quoted that. It's in our heads, my lady. The 4th count, my lady, it's again not the accused refusing to take blame. Because Mr. Nel needs that to try and transfer it into the murder charge. He says, not I don't know anything about the ammunition. I was unaware that my father put it in the safe. He says, no. My father wanted to put his ammunition in a safe place. He asked me, and the father, put it in the safe. But it's not mine. I don't even have a gun that could use that. I thought that's what I can do. And I reminded the court yesterday, and we referred to the section 120, sub 7 and 8, that somehow the Firearm Act does not specify that you must place your firearm in your own safe. And I used the example. I said, what if I go to Mr. Oldwage's house to visit? And I have my firearm, and I don't want to sit around with my firearm. And I say, can I please put my firearm in your safe for safekeeping? He says, yes. The police comes now to the scene, say, open your safe. Ha. Is this your firearm? No, you're guilty. That's Mr. Nell's argument, strict liability. You're guilty. The case law, we quote this case law. It says, no. Possession, 2 elements. Detentio and animus. Detentio, yes, of course. It's there. But he says, I did not have the necessary animus to possess the ammunition. That's a factual finding for the court. You have the evidence. There is nothing to gainsay his version, but for the state in its heads of argument, saying that the father would deny it, and we couldn't understand that. They say they wanted to consult with the father and refused to. Do a 205. Do a section 205. Bring the father. We've got our version. We raised that version at the bail application already to give the state ample notice. Just take a statement from him. If he doesn't want to cooperate, take a statement. You have all the machinery. Is there anything else on record than that version? That it's not mine. The state, in fact, presented the firearm licenses. He doesn't have a license for it. He says, it's my father's. This is the situation. And the court must now find, did he have the animus to possess or only the detentio? If your finding is only the detentio, he must be acquitted. If your finding is he had the animus, he wanted to possess it. For him, he didn't want it. It's not the father's. That's your finding, but that would be contrary to the facts, my lady. But it's a value judgment by the court. We deal with that needs and the case law. My lady, in dealing with the main count, can we look at the real common cause facts? The real common cause facts are the following, and we deal with that in the heads of argument. There were 4 shots fired. 4 holes in the door and 4 empty shells. That's the case. Not 3 shots fired and later 4 shots. Not 3 shots fired and later 3. 4 shots fired. Second fact is that subsequent to the shots, the door was damaged by a cricket bat. It caused a crack. Vermeulen, on that point, is adamant. He explained where the crack was when it started on top of the hole on the right side and then carries on the left side. And he says that can only be when the hole was already there. When that door was cracked, the hole was already there. So that's common cause. So the subsequent event was the cricket bat. And we can debate later, and we'll show you why we're right. 2 or 3 times, he said I could find 2 marks of the cricket bat. When he was asked about the 3rd mark, the high mark, he says, well, when he called him back, if you tell me it's there, it's there. It was actually not my job to look for marks. It was just to see if the door was damaged. I said, excuse me? But you examined the door. No, but that's what he was not there to look at the marks. He was just there to look at the damage. And I say to him, but if you go to your version that he was on his stumps when he hit the door, then you have a problem because that marks 10 to 12 centimeters higher. He says, yes, but then he must have been closer to the door. Now, he's not even trying to match it when he's closer. Then he must have been closer. And what about the power, then I asked him. Won't you have less power? He says, yes. Now we look at Dr. Vasveld's evidence unchallenged to say, but he cannot swing that bat on his stumps. He cannot. Not with sufficient force. Can maybe use one hand, but the other hand he must balance. And then we get a number of concessions and contradictions by Vermeulen. Not important. The important fact is common cause. First the shots, then the cricket bat, and we show conclusively 3 marks. That caused the door to crack. That assisted him in breaking open the panels or some of the panels and getting into the toilet. The third one is that after the shots, the deceased could not have screamed. Dr. Stirp, Professor Simon, and Professor Botha. Common cause. The 4th fact was unchallenged, and I'll get to that. But that is that there were 2 sets of sounds. To be neutral at the moment, I refer to this as the first sounds and the second sounds. According to the witnesses, both sounds resembled gunshots. to a layperson that time of the morning. Of course, if you believe them to be gunshots, if you've just woken up and you hear screaming and you hear doof, 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 they would more and more become gunshots to you. I understand it. But there's also the evidence of Mr. Wolmerans that, and I think it's common sense, that the striking the door by a cricket bat would not be as loud as a firearm shot. I think that's common cause. And forget about the recording. It was not properly proved because of the subsequent evidence. It was not necessary to do it anymore. But we know it's one fact, and it's common sense as well, but we have the evidence of Mr. Wolmerans that a cricket bat impacting against the door, striking, is not as loud as a gunshot. So we have that. Then all we have to do is to now take objective facts and try and determine the timelines. I dealt with that yesterday, and that is from page 34 of the Heads of Argument, but I will sum it up. It's dealt with in detail. But what we say to you there, my lady, is the following. We say that in determining the timeline, what we did, we took telephone data, such as the security telephone data, to say Dr. Stipp called at 3:15. Call duration 16 seconds to report the shooting. We have a 3:16 call by Mr. Nslengethwa reporting the man crying out loud. We have Dr. Stipp saying, I was on the line trying to get through to 10111 at 3:17 when I heard the second sounds, the doof, doof, doof. So we have the exact time of 3:17 and whatever seconds. We have Mr. Johnson saying, I ran down to phone security. Remember, he went through to Struben's cop security, the wrong security. It was 3:16, and I was on my phone for 58 seconds, confirmed by Mrs. Berger. I then ran back, rushed to the balcony. I was on the balcony, heard the screaming and then the shots. So we know it was 3:17 something because it was a short time. It correlates 100% with Dr. Stipp's evidence. So what we know is that the second sounds were at 3:17 and some seconds. That's supported by the witnesses with reliance on the telephone data. What we know about the first sounds, it was before 3:15. That's all we know. Now, in order to try and determine how long before 3:15, we have to extrapolate facts. We say, who can assist us? We say, well, let's look at Mr. Johnson. He had notes. Exhibit Exhibit O. He had notes. 3 times edited notes. First note edited first time and second time edited. He tells us that I woke up about 3:12. About, it can be 3:11, 3:12, 3:13, 3:14. I heard the screaming, and then he tells us about his movements. So what we know more or less, that 3:15 for the shots could have been in the vicinity of 3:12, because the screaming followed at some point the shots. We go to Mrs. Nslengethwa's evidence. She said, I heard the bang. We know that bang sound must have been the last sound echoed by the shots. She woke up, she woke her husband. He subsequently made the call. So we know that's before 3:16. Now, how long before 3:16? We look at her movements. She said, my husband, I told him. He got up, he went to our daughter's bedroom to see that it's safe. He says that he tried to see if there was something downstairs. He came back into the room, he went to the blinds, he peered through the blinds, and then screaming started. If you try and put a time to that movements, you can't be accurate But, it would be anything between 2-3 minutes. It's supported by Mrs. Nhlengethwa. And you take that 2-3 minutes, 4 minutes even, it's not important, before 3:15. And you say, where does it take me? It takes me to about 3:12. It correlates with Mr. Johnson's time, that he heard the screaming at about 3:12. So we know 3:11, 3:12, 3:13, thereabout were the first sounds. We say the shots, but we know that. Let's call it the first sounds. We know that's when they were, and we know 3:17. So we have a 5 minutes, about 4, 5, 6, 3.5, doesn't matter, in between. Now we say, well, let's now see what else we can determine. Let's look at the accused, the man. The accused said it was him, shouting, help, help, help. When would that have been? To see if it correlates with our timeline determination. And then we look at Mrs. Berger, and she says I woke up. Forget about it that she did not give the correct reason why she woke up. But I woke up and after some time, before 3:16, because she went down 3:16 to make the call. Before 3:16, between me waking up, and we know that was about 3:12, I heard help, help, help. Mr. Johnson exactly the same. Help, help, help. The accused version. It's not too long after the shots when I realized. I went out onto the balcony and I shouted, help, help, help. It fits in, absolutely, the puzzle. We go to Carice Viljoen. We say, can you help us? She heard help, help, help. She says, yes. The call came through to my father at 3:19. I was awake because of the dogs barking. I looked outside the sliding door. I got back into the bed and I heard the help, help, help. And we say now, in relation to the 3:19, more or less, how long before that? She says, about 5 minutes. If I think about my movements, it's about 5 minutes. You say, well, let's see if you're correct. Take the 3:19 call. We have the exact objective fact. Take about 5 minutes back. It tells you 3:14 was the help, 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 more or less. You see, but hang on. That's absolutely what Mr. Johnson is saying. It was a little while after waking up, the 3:12. It is what Mrs. Berger was saying. So we know now at about 3:14, 3:15, 3:13, there was the help, help, help. So we could determine that and say now at least we know 4 things. We know that the first shots were about 3:12. I only say 3:12, not to say about 3:11, 12, 13, 14, about 3:12. We know the help, help, help was about 2 minutes later. We know the screaming was in that time between the first and the second shots. And we know for a fact the second shot was 3:17. Whether it was 3:17, 20, 30 or 40, we don't know. But we know it was 3:17. So we have those times. There was one complicating factor, and it was Dr. Stipp. We'll show you many things about Dr. Stipp. He was then the only one saying, oh no, that help, help, help was after the security guards had came to me, and after I'd made a call at 3:27, and after they had left a few minutes later, which was after 3:30, I heard a man shouting, help, help, help. And you say, really? Really? Because at that time, Dr. Stipp was at the house of the accused. At that time, the accused was on all the evidence unchallenged in the foyer with the deceased and with Gerrie Stander and Johan Stander standing outside and Dr. Stipp examining him. So, examining the deceased. So it cannot be. And I'll show you many things about Dr. Stipp that cannot be. Many, many things. And Mrs. Stipp. So we know we can ignore that part. So that's what I'm saying in all these pages that we're submitting to you. We go and we sum up every witness's evidence, to show, to demonstrate, with reference to objective facts, why we can confidently make that submission. And we say now at least it's extremely helpful. Now we know the timeline. And may I do this, my lady? Because it is quite important. Ask you to go to page 91 of the Heads of Argument. I apologize, my lady, it is. Where's the time chronology? Summing up. If I just may find the correct place. It's a summing up of the time chronology. Because we dealt with it in detail, and then we sum. It's page 60. My apologies, my lady. That's where we summed it up. Starting summarize. We say summarize, and then we deal with it in detail, in far more detail that I've submitted to you. We give you the important times, and this is the relevance, my lady, that could be established, A, by making use of objective facts. We had the cell phone data, or the witnesses unchallenged on their cell phone data. We had the security telephone data, times of the calls. We have the, they put in a plug, the security, when they walk their rounds. Guard track, when they activate it. We have the exact times of that. So we could take all of that together, the objective evidence, then determine where the witnesses' evidence correlated with that. To say, well, it's not a mere say-so. We have no objective facts, or where we accept the evidence was supported by cell phone data or objective facts. So we know then the following. That this is important, because we'll come back to this. At 2:20, because we have the exact time, security activated the guard track next to the house of the accused. I can be naughty and tell you why that's important already now. It's important. It was Mr. Peter Barber. It's right there at the accused's house. If there was this arguing, and more so downstairs in the kitchen, it was very close. We saw the photos where he activated on the pole, lamppost. Then surely Mr. Peter Barber would not be intimidated by any one of us. He would have said, and you know what was strange, 2:20 in the morning? I heard this incessant talking. I heard this arguing in the house of the accused. What did he say? Everything was normal. That's a security line. Everything was normal. 2:20 arguing. That's not normal. He would have told us. That's Mr. Peter Barber. That's how I summed him up. He would have told us. What did he not say? He said everything was normal. He didn't tell us about any argument, and it is fatal for the state, because that is 2:20. That is when Mrs. van der Merwe, according to the state, and we'll make our submissions there, would have heard this voice, arguing voice. This objective fact cannot be. Cannot be at the accused's house. The second fact, I may say, my lady, we also showed later on Mr. Peter Barber's evidence, 2, 3, and 4 minutes later, he passed the house of the accused again, going to other stands. Everything normal, no problem. So it's not only 2:20 that there was a lull. It's also for the next 2 minutes and 2 minutes again, when he passed, about 4 minutes later. Still nothing. Then we get to the second time. We say the first sound, approximately 3:12 to 3:14. It's irrelevant. I could just have said 3:12. The shouting for help, approximately 3:14, 3:15. Well, thereabout. The time of the screaming, approximately between 3:12 and 3:17. I come back to this point, 3:15, accused seen walking in the bathroom. That's very important, my lady. And we deal with this in detail. But we know Mrs. Stipp told us just before Dr. Stipp went into the house to make the phone call to security. And we know when that was, he made the call at 3:15. And then again a call at 3:17. Just as that time, Dr. Stipp said to you, he'd seen a man walking in the bathroom with a fair complexion. We know that it could only have been the accused in the bathroom. We know that he did not have a shirt on. We see the photos. We know that he has a fair complexion. And then more importantly, my lady, and we'll deal with that, we know that Dr. Stipp said he also saw him on the right-hand side of the window, which said, but there were branches at the bottom part, the tree. He says, no, you could see him from the top half. And we gave you the measurements later to show that if you saw the fair complexion through the right-hand window, when the accused was on his stumps, 144 when he's walking, 152 when he's not walking because he's more up straight then. It's not possible. He's not in the top half. He could only be on his legs. And then we say, whoa, but this is important. Because we know now, on the state's evidence, that at 3:15, the accused was in the bathroom. And we look at the accused version and we say, it makes sense. You know, he went in the bathroom, tried to open the door, get back to get the cricket bat. He was then on his legs. We know that. He was then on his legs, and we say, but hang on. Common cause fact, he was on his stumps when he shot. Unless the state's submission that he quickly took off his prosthesis to fire the shots and then put it back and hit which is ludicrous, to hit the door with the bat. We know on the state's own evidence that just before 3:15, the telephone call, he was on his prosthesis. And that tells you, it's damning with respect, that the first sounds could only have been the shots. And the second, but we give you many more facts. And the second sounds could only be the cricket bat. Because there is state evidence proof for that. But we'll come to that, my lady. Then we know, on the next page, at 3:15:51, there was a phone call by Dr. Stipp that lasted, the duration was 16 seconds. We know at 3:16 there was a phone call by Mr. Johnson to Strubenskop Security, lasting for 58 seconds. We know at 3:16:13 Mr. Mslengetwa attempted his first call to security. It did not go through. And we know why it didn't go through. You just have to go up to paragraph 188. Dr. Stipp was on the line with security. You can see it. Then 3:16:13, duration 44 seconds, is his second call when he spoke to security and he said to them, there's a man crying out loud. 3:17, Dr. Stipp's attempted call to 10111. 3:17, then the second sounds. We've dealt with that because it combines with Mr. Johnson's evidence. Then we know exact time, 3:19:03, duration 24 seconds. Accused call to Hans Stander. We know 3:20:05, accused call to 911. 3:21:33, duration 9 seconds, accused call to security. 3:22:05, security's call to the accused. And 3:22, Peter Baba arrived at the house. Now, if I may just mention it at this point. This is so important because Mr. Peter Baba told the court that he received a call, Mr. Ngetwa's call and Dr. Stipp's call. And we know that it was 3:15 and 3:16. As a result of that, he went to Dr. Stipp's house. So Dr. Stipp's story that call did not go through is false, two ways. One, the call register shows that call went through. Secondly, the second call that he said went through later on did not go through. Objective evidence. Secondly, Mr. Peter Baba reacted to Mr. Stipp's call and went to his house, spoke to him. He was on the balcony, Dr. Stipp. He was down in the street. That was observed by Mr. Nslengeti. He saw them through the blinds. He saw them. And then he said he saw Mr. Baba driving in the direction of the accused house. And then he saw the white 4x4 vehicle of Dr. Stipp also doing that. And then we know, when did Mr. Baba arrive at the accused house? He says, I was right in front of his house when I called him. And we have to call register 322. And he says he got out and he saw the accused carrying the deceased down. So we know it was 322, make it 322:30, make it 323. But then it's better. We get further evidence. We get the evidence of Gerrie Nel and Johan Stander saying, I received a call at 3:19. It's not far. We drove as quickly as we could. And I can tell the court as a fact we would have been there within 3 minutes, which is 3:22. And it makes sense, my lady, because what did they observe upon their arrival? They saw, like Mr. Peter Baba, the accused carrying the deceased down the stairs. So it slots in 100%. 100%. But for who? Dr. Stipp. According to Dr. Stipp, his call didn't go through. It must have been a coincidence that the call register showed 16 seconds. It must be a coincidence that Mr. Peter Baba reacted to his call that didn't go through. It must have been a coincidence that his 327 call, which he said went through, did not go through according to the call data. And by that time, he was already at the accused's house. He said he stood next to Mr. Stander when Mr. Stander phoned 911. That's 327. We'll get to that. He had already then tried to phone the Wilgers, and the Wilgers said, no, phone 911. So we go to the next time. At the bottom was 322, Johan Stander and Gerrie Nel arrived at the house of the accused. Then we say it's approximate. Top of page 62. 323, 324, Dr. Stipp arrived at the house. Why do we say that? For the following reasons. We know he followed shortly after Mr. Peter Baba. We know Mr. Peter Baba arrived at the accused house at 322. We know that the Standers arrived at about 322. Gerrie Nel now and Johan Stander. We know that they say to us that the Stipp arrived shortly thereafter. We know that Mr. Nslengeti says to us, he saw, after making that call, he saw the security because he was concerned about the screaming. He saw security going to the house of Dr. Stipp. He saw security leaving, and then he saw the white 4x4 of Dr. Stipp leaving. So everyone, it just goes to one point, and that is that it is so. So we know then what Dr. Stipp did. He examined the deceased. He then realized there was no hope. He walked out. He met Dr. Johan Stander. He tried to phone the Wilgers. That's his evidence, unchallenged, state evidence. The Wilgers told him no, phone 911. Johan Stipp then, and that's the next point, 32706. Johan Stander's called to 911 in the presence of Dr. Stipp. That's the evidence of Dr. Stipp, and that's the evidence of Johan Stander. Next time, 32714. Dr. Stipp's attempted call to security. Now, according to Dr. Stipp, he was at his house, and that's only when he got through to security. It cannot be that call did not go through. We can only surmise why he was phoning, and I believe it was to tell the gate, we've phoned the ambulance, there's an ambulance on its way. But he didn't get through. Then 34158, my lady, Lynette assessors, you would remember, by consent, we handed that photo up late at the gate. It shows the ambulance arriving, 341:58. Then 350, it was the declaration of death by the paramedics. We have the unchallenged evidence of Gerrie Nel and the accused then going upstairs to collect their identity document. And approximately 3:55, that comes out in the evidence, the police arrived. And we know the police arrived, and that must be right, because the police arrived after the accused had gone upstairs. Because Colonel van Rensburg would have told us when he was there, the accused went upstairs. And it's not so. We also know it was after the declaration of death by the paramedics. They arrived after that. So that also makes sense, the 3:55. My lady, I'm going to start with a new point, and I just need a second breath. Can we take it a bit? It's about 7 minutes past, and we can resume earlier again. I'm in your hands.
We'll take a 15 minutes break.
That's my book.
The steps were two sets. Steps were two sets of shots.
I'm not sure about that. I'm not sure about the steps hearing. There was a couple who heard two sets of shots or sounds.
Schellberger didn't hear the first shot. She woke up to blood-curdling screaming, and she heard 4 shots. Her husband heard 5 or 6. The Stips heard two sets of shots.
Yeah, 2 sets of shots. But what he's trying to say is that there's no doubt in his mind that the first set of shots was the gunshot, and that happened before 3:17.
He's challenging the state's time.
John, straight through from an insert, VT, and then you throw back to studio there. The guy's got 6 minutes.
We'll talk also about the lesser counts, because those have been dealt with. But
Yeah.
there was a weird admission on the Tasha's
He said that he should be found guilty on the alternative
charge, which is negligence.
negligence.
Guys, I think can we stand with you two here? So we don't Q, you're on -3. And you throw back to Debbie when you're done. Guys, we're ready for you. Just, 1 minute.
It's cold. It's getting cold.
John, they will be counting you in.
Sorry?
Counting you in? Whatever his name is in this thing will count you in as well.
Yeah, I've got you. Thank you.
Stand by, guys. 10, 9, 8, 7, 6.
Barry Roux for the defence addressing the court on day 41 of the Oscar Pistorius murder trial. He's presenting his closing argument in this trial, and just prior to the tea break, really, he was going into some detail around the all-important timeline. We knew he was going to do this on the basis of what he said in the final half an hour of yesterday, but he's providing a great deal of detail around this very clear timeline that the defence has drawn up on the basis of the phone records. But in that insert you've just watched, he also provided some clarity on what Oscar Pistorius' defence is. It seems to be putative private defence on the basis of the fact that his reaction was reflexive, that he shot reflexively, and yet there was a cognitive process attached to that. So it's seen in combination, it is the view of the defence that he acted in putative self-defence. More on that, obviously, a little bit later, and our legal experts here on Channel 199 will be able to provide some greater clarity on that particular issue. But here to provide some clarity on other issues relating to what we've heard today, Gerrie Nel of the Eyewitness News team. Gerrie, let's talk, there's so much to talk about, and we will reflect, of course, on the timeline. But firstly, let's speak about the lesser charges that were dealt with by Barry Roux today, counts 2, 3 and 4 on the indictment. And a little interesting twist, I guess, as far as count 3 is concerned, which is the accidental discharge of a weapon inside the Tasha's restaurant at Melrose Arch. There seemed to be an admission by Barry Roux that on that particular charge, Oscar Pistorius should be found guilty. Tell us a bit more about that.
That's right, John. And of course, he's talking really about the alternative in that charge, meaning that Oscar Pistorius should be found negligent in terms of handling that particular firearm. And it really comes down to what Oscar Pistorius said during his testimony, that he was handed this gun. He didn't know how it went off, but he didn't pull the trigger. And Barry Roux admitted today in court that he should have never taken that gun. It should have never been handed over to him. He should have never handled that firearm in a busy restaurant with children sitting nearby. But unfortunately, it did discharge in that restaurant. And he's saying that something could have been wrong with the gun. It could have been a number of reasons, but Oscar Pistorius maintains that he didn't pull that actual trigger. He says perhaps his finger was on the trigger and accidentally, without realizing, he did in fact pull the trigger. But he says that in terms of being negligent, Oscar Pistorius should be found guilty. And as we know, Oscar Pistorius has pleaded not guilty to all the charges. So it is quite interesting that we actually have Barry Roux coming forward saying that he should be found guilty on some aspect of this particular charge.
Count 2 on the indictment is the firing of a weapon through the sunroof of a car that was being driven allegedly by Darren Fresco, Oscar Pistorius' friend at the time. Aspersions cast on the evidence of Darren Fresco and Samantha Taylor as far as that particular charge is concerned by Barry Roux, suggesting that both perhaps had an agenda.
That's right, and you've actually seen Barry Roux actually saying that today, saying that, of course, a lot of discrepancies coming through Fresco's testimony. He contradicted himself many times, and just sitting in the court, you could actually hear that. He did contradict himself many times. But at the same time, we get to a situation where Barry Roux is trying to say, does this charge still stick if there's no absolute 100% fact or evidence which shows that he did, in fact, discharge that firearm through the sunroof. And again, we've got an ex-girlfriend, a friend who's come out and testified against him. Do they have an agenda against Oscar Pistorius? Is there some bad blood at the moment? And he's really put that forward to the court.
In about a minute or so, which is the timeline we have available to us, let's talk about the timeline discussed by Barry Roux. It's very clear that they disagree with the state as far as when the shots took place, when the shots were fired, the gunshots, that is. It is the state's, the defence's view on the basis of the phone records that the shots were fired at 12 minutes past 3 in the morning or thereabouts, and that the cricket bat was used at about 17 minutes past 3.
Very different to the state's case, and this is the major difference between the two cases. The state actually says that, of course, the gunshots were fired about 3:17 a.m. Barry Roux is saying that that is when the neighbours actually heard the cricket bat sounds. So he's really trying to distinguish the difference here, and he's backed it up by phone records, saying that certain neighbours phoned security, etc. Oscar Pistorius had made phone calls himself, and he says it just wouldn't have made sense for Oscar Pistorius to have fired those shots at 3:17 and then made a call just 2 minutes later for help when he had already broken down the door, only giving him that 2-minute gap period. So he's saying that the gunshots were definitely fired at around 3:12, 3:14 a.m. But of course disputing the fact that the other neighbours who only heard one set of shots or one set of sounds, saying that they in fact heard the cricket bat sounds and not the gunshots.
Gerrie Nel, as always, thanks very much indeed for your input. Gerrie Nel of the Eyewitness News team will rejoin us a little bit later on this morning and throughout the rest of the afternoon. Well, the wind is swirling around outside the High Court, much as the facts have been inside the courtroom. Plenty to discuss here on Channel 199. For now, Devi, it's back to you in Johannesburg.
Thanks, guys. Well done, guys.
Thank you.
Nice little creative flourish there, John.
you want to...
Yes, Mr.
Thank you for the indulgence, my lady. My lady, I'm going to deal, but I don't want you to go to that page, but I'm going to deal with the first sounds to demonstrate to you why the first sounds were the gunshots. But before I do that, my lady, it is important to deal with Dr. Stipp's evidence to remove the last obstacle to the submission that I'm going to make to you. Now, Dr. Stipp's evidence, the main part of his evidence is in Annexure A. And the reason why I'm dealing at this stage of Dr. Stipp's evidence is this. I made reference to Mrs. Stipp's evidence to say that when Dr. Stipp walked inside from the balcony to make the call at 3:15, he told her about the man, well, we know it's the accused walking in the bathroom. Now, that is crucially important because we know that single fact, and we will combine it with other facts, shows that 317 sounds must have been the cricket bat for many, many reasons, but it must have been because he was on his prosthesis, and we know he was on his stumps when he shot. So he was already by then on his prosthesis. And why are we dealing with Dr. Stipp? Because as with the help, what he has done, he then decided to move him observing the accused in the bathroom to a much later time. Contrary to Mrs. Stipp's evidence. And we're going to show to you why his evidence is not only unreliable, but must be untruthful in that regard. We're going to show to you in detail. And it's for that reason that I'm dealing with Dr. Stipp's evidence. Now, what Dr. Stipp, and I will sum it up, it's all there in Annexure A. What he was doing, because he so desperately, with respect, wanted to assist the state. And he did the following. He said that he, in summary, woke up, hearing the 3 gunshots, and then it was a question of moments. He was on the balcony, and moments he heard the screaming, and he saw the lights on. And then he's back in the bedroom, and he makes the call at 3:15, and he says it didn't go through, and he tried to phone 10777, it didn't go through. And then there's a lapse. We don't know then. And then he jumps to 327 because he had to. He could not explain the time between 317 and 327. And we will show to you that it's all wrong. But that is the gist that I've just summed up of his version. He says then at 327, gives us no explanation of really what's happening between 317 and 327 because he couldn't. And then he says at 327, he phoned security, he spoke to them. That call didn't go through. Then Mr. Peter Baba came to him. It's not so, we know that was after the first call. Mr. Peter Baba was after 327, a long time at the house of the accused. So I'll pick up at in Annexure A. You'll see paragraph 7. He was still on the phone when he heard another 3 loud bangs. That was at 317. And then you will see the 10-minute gap. And he eventually got through to security when he phoned at 327. And he says he spoke to the guard on duty at 327. And that security informed him that they were just waiting for a duty manager. And then he found himself on the balcony again. And that is when he heard the man's voice shouting, "Help, help, help." That's now after 327. Sometime after, a minute or two, we don't know. And then he says security arrived a few minutes later. That must have then been after 3:30. Make it 3:30, 3:29, 3:31. Doesn't matter, a few minutes. He says that he went out onto the balcony, watching them as they went. He then saw someone walking in the bathroom from the right to the left. I've dealt with that. He then returned to his bedroom and then first drove to security, to the gate, and then to the accused house. Now we know now in his version, and taking his times, this was now after 3:35. Now let's take now that position. He says then he examined the deceased. He spoke to Johan Stander. He was with Johan Stander when Johan Stander made the call at 9:11. He then saw the accused going up and he asked Johan Stander if he knew where the gun was. And then a few minutes later, the accused returned from upstairs. Now we take this evidence and we start to measure it against the objective facts. So we know the first thing that we must look at is this moments, this very short time of his, between the first and the second shots. And that was important for the state, because the state desperately wanted the bathroom lights to be on, more or less or shortly after the first shots. But let's see if it was possible, if we can rely on him. My lady, if I may ask something, page 4, paragraph 21.3.1. There's a wrong statement. We say we have demonstrated above it could not have been approximately 5 minutes, but about 2 to 3 minutes. No, it's wrong. It's in fact 5 minutes. It's after we checked the timelines, we corrected it. I just omitted to correct that. It is 5 minutes. So you can delete just 2 to 3 minutes. I addressed you on that. Now, let's start to compare his evidence. There's moments. We first go to Mr. Johnson and Mrs. Berger's evidence in paragraph 21.3.1. What they say to us, that about 5 minutes lapsed between the time that they heard the screaming and the time of the second sounds. So that immediately places a big question mark on that short time given by Dr. Stubb. The moments here, moments there. But that's just the one. Then we look at Mr. and Mrs. Slingetwa's testimony. And we look in relation to the 316 and all their movements before Mr. Nslengethwa made the call at 3:16. And we know it can't be moments. We know it takes us back again to about 3:12, 3:13. And it takes us back to the same 5 minutes of Mr. Johnson and Mrs. Berger. So it refutes the moments. Then we go to Mrs. Stipp, 2:15. Now, Mrs. Stipp, she started with 02:59 because the clock radio was 3 minutes, and in her time it was 18 minutes. Well, we know it can't be moments, but 18 minutes is wrong. It cannot be. She's now stretching it beyond acceptability between the shots. Then we do something more. We say, let's look at the consistency of this, Dr. Stipp, to look at this short time space between the first shots, first sounds, and the second sounds. And that is his Exhibit P1. And there's also Exhibit P2, his affidavits. And if you look at his affidavits, my lady, there was a period of 17 minutes between the first sounds and the second sounds, which is absolutely refuting his short moments. Where is that? That also can't be. It shows you cannot rely on his evidence. That was in his statement. Then you look at his evidence that he made a call of 3:15 that did not go through, and you see that's false. Because the telephone data shows you it did go through, and Mr. Peter Baba spoke to him and went to his house after 3:15, not after 3:27. Then you look at Mr. Nslengethwa's evidence to say, Mr. Nslengethwa, when did you switch your lights on that they could see that all the inside lights were on? He says after the phone call, not before his 3:16 phone call, after that, and he explains that. He says, I wouldn't switch the lights on. I don't know what's going on outside. I don't want them to identify me as a target. Why would I switch the lights on before? He refutes that the lights in his house are on. And what's important about that? Because Dr. Stipp's evidence is supported by Mrs. Stipp, who was not on the balcony, and said she was, that he saw simultaneously, when he went into the balcony, all the inside lights on in Mr. Nslengethwa's house and the bathroom light. Now, if that time of Mr. Nslengethwa's house, the time of the lights is wrong, then the bathroom must also be wrong, because he compared the two. And Mr. Nslengethwa said, why would I switch my lights on in the beginning? I did not. I had dim inside lights on, but you see a little line through my blinds, not all the inside lights on. And he was not challenged on that. And that's his evidence. He had no reason to lie. In fact, he was so honest. When Mr. Nel asked him, can you say anything about the accused bathroom lights? He said, I didn't look. I don't know. But we know that was the reference of Dr. Stipp. Nslengethwa's house lights on and the accused. Now, if he's wrong about the one, what do we do with the second one? Then, my lady, he says, and I move on to page 8. Mrs. Stipp then tried to corroborate Dr. Stipp's evidence. That's paragraph 22.8. And she tells us when she was on the bed, she could clearly see, and I've dealt with the curtain, why it was necessary to keep the curtain open. But then she says, at page 1103, she moved to the bigger balcony to have a better view. And one thing we do know, Dr. Stipp said, no, she was not on that bigger balcony. She was on her way, and I met her when I went inside. She was still in the main bedroom on the way. So it's not true. Then, what is so important, if we look at the bathroom lights, that's page 23 of the heads. We handed in photos.
It's paragraph 23.
Paragraph 23, my lady. My apologies, page 9. We took photos of the deceased house where, because the toilet light was not working, there was no dispute about that. You switch on the bathroom lights in the evening, and you close the toilet door. Then the toilet window was obviously dark. You open the toilet door. Then the toilet window is illuminated, but not to the same extent as the bathroom, because it's light shining from the bathroom into the toilet through the open toilet door. You've got the photos. It's put before you. And that correlated with Dr. Stipp's evidence. He said the lights on the right were more intense than on the left. That's absolutely correct. Absolutely correct. But it tells us one thing. When he saw the lights, the toilet door was already open. It's after 3:17. The toilet door was already open. That's the only way the lights could be more intense on the right than the left. Otherwise, it could not be. That's apart from his difficulty with Mr. Nsangetwa, but it exposes that. Then, my lady, and we have all the parts of the more brighter on the right, more intense on the right, is evidence. Then we move to page 12, and we again shortly refer to Peter Barber's evidence to say, I got a call from Dr. Stipp at 3:15. He spoke to me and I went to his house. And I arrived at the accused house from Dr. Stipp's house already at 3:22. So he couldn't have phoned me at 3:27. It's not true. His call did go through. And we deal in page 13 with his 3:27 call to say that did not go through because he was already at the accused's house. We deal with Mr. Johnson's evidence and everyone else's evidence when they heard the help, the following pages to show that Dr. Stipp's evidence of help was not true. Then page 15, my lady, paragraph 27, the 7th incorrect point, materially incorrect point in Dr. Stipp's evidence. Look what he did then. His wife's evidence is this. She says when he walked in to the bedroom from the balcony, he told her, just before he made the calls, that's just before 3:15 or 3:15, he told me about him seeing the man walking in the bathroom. She goes further in her evidence. When she testified, she said, in fact, when security came to our house, which we know was before 3:22, because that's Mr. Peter Barber, a minute or two before 3:22. I told them what my husband had seen, and I pointed to the accused house. I told security. So she already at that time was in a position before 3:22, because Mr. Peter Barber arrived at the accused house at 3:22 from Dr. Stipp's house. She was already in a position to share with Mr. Peter Barber her husband's version that he had seen the man walking in the bathroom. So that clearly deals with the contention of Dr. Stipp that it was after 3:30, after security had come. And when they drove away, they came a few minutes after 3:27. And then they drove away, and as he was looking, he saw the man walking. So that's after 3:30. It's not only that Mrs. Stipp's evidence takes care of that, to say, no, told me at 3:15, and in fact, before 3:22, I told security already about it. His evidence is impossible, because we know after 3:30 or 3:30, he was already at the house of the accused, because he was next to Johan Stander when he phoned 911, and it already phoned the Wilgers from the accused house, and it already examined the deceased. So it's false, but we say it's not an accident. It's not unreliability, because it occurs time and time and time again. And the reason is he understood the devastation for the state's election to make the shots 3:17. If there was a man if the accused was on his procedures before 3:17, shortly before 3:17, it's bad for the state. And he just moved the time on, like many other things. But I'll show you what else he did, my lady. That's not the only thing. I deal with smaller issues. I'm leaving that aside. And his minutes, and the minutes that the accused went upstairs, where Gerrie Nel said it was not even a half a minute, because she was concerned about him. She could still hear him going up, and she thought she's concerned, and she went upstairs. I want to... And we deal with this in detail. What he does, if I may ask you to go to page 18 of Annex A. He made 2 affidavits. And I'm dealing now with the second, the screaming. He says in the first affidavit, he heard a woman screaming 2 or 3 times. Not too important. In his second affidavit, he says about 3 times. Not too important. And he says in his statements he gave the events as the best I could recollect. It was fresh in his memory. He said then in his evidence in chief, it sounded to him, not it is, it sounded to him like a voice of a female. He used the word sounded. But then, my lady, that screaming became extremely fearful, severe emotional anguish, almost scared out of my mind. Her mind. And you know when he did this, my lady, if you go to the record, there was a lunch adjournment. He came back from the lunch adjournment, and he was then miraculously in a position to increase the emotion. Contrary to his affidavits, contrary to his statement to Mr. Stander, he heard shots, screams, and then shots. It became then extremely fearful, severe emotional anguish, almost scared out of her mind. I don't know what happened between 1 and 2. How would I know?
Was he asked? Was he asked a question?
No, my lady.
What happened?
No, my lady, it's not asked. It's a cold fact. It's a cold fact.
Yes, but what are we to make of it?
My lady, what I make of this is a man, apart from the 10 serious material contradictions, just talk about 2 to 3 screams, just describe them as screams in 2 affidavits, just describe them to Johan Stander as shooting, scream, shooting, sounded like a female, and then go on a lunch adjournment, and he comes back, and it becomes severely emotional. It's there.
What's wrong with that addition?
My lady, 2 things. The one is, it's not in his 2 affidavits. It's not in the version to Johan Stander. And it then suddenly comes out. Why did he not tell us that before? Why he says, in the statement he dealt with as best as he could, especially, it's there, 2 statements. Why did he not say that? Why not? It's an inference. But you have to take that one inference, and you have to take it now back to his evidence, where his moments are not correct. It's absolutely contrary to his previous 17 minutes, it became moments, where his lights in Mrs. Ngetwa's house could not be correct, where his 315 telephone could not be correct, when seeing the man is not correct, when his second call is not correct, and when he went to the accused's house is not correct, and when he heard the help is not correct. you put them all in one bag and say, what must we do with that? And all I say is this: you cannot rely on him. You have to put a big question mark on his evidence. Everything cannot be incorrect. Everything cannot refute the objective evidence. 10 material points. It cannot be, my lady. There's a problem. But I say, take that then and put it back in the pot in the context of all the facts, and then consider the facts. But factually then you say, but his evidence is inconsistent with the other state witnesses' evidence on those material effects. It's inconsistent with the objective evidence. It cannot be. That's what you do with it, my lady. You don't have to call him a liar. You must ask yourself the question, can you rely on his evidence in view of the 10 material defects in his evidence? You cannot, my lady. It may be a coincidence that during the lunchtime he was thinking about it and he then remembered that the screaming was far more emotional. That may be. But I'm not sure that it is if you compare how he adapted his evidence on material aspects. Then I'm concerned. I can't put it higher. I can't say anything more. But I can say I'm concerned. If it was just an isolated incident, yes, it's possible. But it's not. That's the only submission we make. That conduct of his is not, or was not, isolated. So, my lady, what we say to you in then coming to the first sounds, at page 96, that reliance could not be placed on the timings, on the timelines of Dr. Stipp. It offended the objective evidence. So we have to look at the timelines in the context then. And we make the submission that you have, how it was described, and I'm going to keep the description. You have 3 shots by Dr. Stipp, 3 shots by Mrs. Stipp when they woke up or just after having woken up. And then you have some time later, we say on the evidence 5 minutes later about, you have 3 shots. Dr. Stipp, 3 shots. Mrs. Stipp. Then you move back and say, what about the other witnesses? You say, well, we have determined when the screaming was. Sounded like a female. That was between 3:12 about, the first shots, first sounds and the second sounds in that time period. That's when it was. So we go to Mr. Slingetwa's evidence, because now we have this confusion. We have Mrs. Berger hearing a woman screaming, and I'll get to that. Staying in a bedroom. You have going to his balcony because he couldn't hear properly in his bedroom. That's why he went to the balcony. Mr. Johnson hearing a woman screaming. In that time period, you have Mrs. Stipp hearing a woman screaming, and you have Dr. Stipp hearing a woman screaming. Go back to the evidence. Is that all that they heard? No. Mrs. Berger and Mr. Johnson also heard help, help, help. Dr. Stipp could also, before 3:15, when he was still on the balcony, could also hear a man screaming, not only a woman. It says intermingled. According to Johnson Berger, They heard a man and a woman. Not intermingled, a man and a woman. According to Dr. Stipp, intermingled a man and a woman screaming. Importantly, after 3:15, Dr. Stipp did not hear any more screaming to 3:17. But Mrs. Stipp, after 3:17, also heard with a woman screaming, a man screaming. So it tells us that on an analysis of the version, there was a continuous screaming by a woman, and also the man was not only at one stage, he was screaming. We know he was screaming before 3:15, according to Dr. Stipp, and after 3:17, after 3:15, also heard by Mrs. Stipp. She heard it. So it was more than one screaming by a man. Then we go to Mr. Johnson and Mrs. Berger to say, what was the real nature of the screaming by the man? Now, there's evidence. Let's go to their notes. The notes of Mr. Johnson agreed to by Mrs. Berger. He says it was not as if it was a fight. It was as if they were being attacked. Anxious screaming. Not only the woman. Both. Anxious screaming. As if they were being attacked. Later in evidence, of course, Mrs. Berger suggested it might be a mockery, and Mr. Johnson suggested it might be monotone voice. That's not in his notes that he professed to be so accurate. That's not what it says. It says one thing clearly. It was not fighting screaming. It was as if they were being attacked. Not only the woman, the screaming by both of them. So we know that we have anxious screaming by man. And we know we have a man screaming, help, 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 in that time. Between the first and the second shots. Now, if you look then at Mrs. van der Merwe's evidence, she said that what she heard was this woman's voice, far away, could not make out language, sounded to her like arguing. Let's accept that for a moment. She got up, could not sleep, looked in the opposite direction of the farm, not in the direction of the accused house. If I may fast forward, however, when sound tests were being done in February 2014, she also got up, walked to farm in, and in the direction of the accused house. Not on 14 February 2013. Never ever. Also walked in the direction of the accused house. That's telling. And I've dealt with Mr. Barber's evidence. He was right outside the house of the accused in that crucial time. We know that she did not hear a constant voice. We know that she could not say that before the shots. It was still talking. She just heard it from time to time. But what we do know is this. On the state's case, on her evidence, and in the further particulars, there was an argument and note, not screaming, and then the shots. 4 shots. Now the 4 shots we understand. There were 4 shots fired. The woman's voice we've dealt with. Far away, walking in the wrong direction. Not constant. But we know one thing. On her evidence, Mrs. van der Merwe, there can be no doubt. She did not hear screaming, and then she heard 4 shots, and after that, she heard a woman crying loud. And her husband said to her, no, it's not a woman crying out loud, it's the accused. That's her evidence. So we know that after her hearing the 4 shots, she heard the crying, the loud crying. It is not a coincidence that the 4 shots correlate with the 4 shots fired by the accused. Now we know. The second state's case, they say there was screaming and then the shots. And we know there were first shots, then screaming, and then the shots. So now the shots moved from the 4 shots heard by Mrs. van der Merwe to the second sounds heard. It moved on. It cannot be. Both cannot be. Then you ask yourself the question, and you say, what was this screaming? It could have been the deceased screaming under one version. However, we know that the screaming heard by Johnson, Burger, Stip and Stip was the same screaming heard by Mr. and Mrs. Nhlengetwa and Ms. Motswane. We have the exact times. If I may repeat, before 3:16, Mrs. Nhlengetwa heard this bang. She was worried. There were some movements of her husband inspecting, and then they heard the screaming, which is consistent with the accused version. There was a short time lapse between the shots and the screaming. But what we do know, what is important, my lady, is that it was after the first shots, there was the screaming. That is consistent with the Johnson, Burger, Stip and Stip's evidence. After the first shots, the screaming. They interpreted the screaming as a woman screaming. Mrs. Nhlengetwa said, no, I'm next door. It was not a woman. It was a man crying out for help, loud, in a high-pitched voice. Mrs. Nhlengetwa, he was a brilliant witness. Mrs. Nhlengetwa, exactly the same. She tells about the help, 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 followed by the screaming. High-pitched voice, not a woman, crying out, desperate for help. That's how the same time between the first and the second sound. Time-wise, we've shown to you in the timeline. It's exactly the same time. Miss Motswane, she hasn't got the privilege of a telephone call like Mr. and Mrs. Nhlengetwa, the 316, which is before 317. Because at 316, Mrs. Nhlengetwa already reported the man screaming to security. It's before 317. Mrs. Motswane says the following: I woke up because of this crying out loud, desperate, and she imitated it in court. Not weeping, they explained their understanding of crying and crying out loud. It's someone desperate, loud screaming, and we know we have the high-pitched voice in Nhlengetwa's evidence. But then she tells us something, because we need to put a time to when she heard the screaming. She says, yes, in my affidavit, I said it was about 3:20 because I didn't know. I guessed. But we know it could not have been 3:20 because at 3:20 there was no screaming. On the state's case itself. So they said it stopped at 3:17, and we know 3:20, 3:19, the accused was on the telephone, 3:20 he was on the telephone, 3:21 he was on the telephone, and 3:22 he was on the telephone. So we know it could not be 3:20. So we asked her, we said, Mrs. Motswane, let's try and find out, put a time to when you heard the screaming, this crying out loud that you imitate in court. She says, well, I heard a car, and I looked through the small window on the other side of my house. And I said to my husband, I've just seen a Mini Cooper stopping. We know who that was. That was Gerrie Nel and Mr. Stander. And we know when they arrived, they supported by Mr. Baba at about 3:22 seconds to the left or to the right. And we say, how long before that was that you heard the screaming? She says definitely more than 5 minutes, but not more than 10. So if you take that time period that you heard the screaming from 3:22, it takes you, by the way, exactly to between roughly 3:12 and 3:17. Between 5 and 10 minutes from 3:22. Exactly the same. So it supports all the other evidence when that screaming was. We know it was the same screaming. So it is there. Now we have to ask ourselves the question. The accused version was that I fired a shot and then hit the door hard. That's supported by Mr. Colonel Vermeulen, the sequence there. So we know if you sit back and you have the 4 shots heard in quick succession by Mrs. van der Merwe, it is exactly on par with the accused version. Mrs. Stipp tells us there were 3. She woke up from a bout of coughing. Mrs. Stipp was asleep. I can understand 3 or 4 shots. You wake up because of the shots. So the 3 to the 4 makes no difference. However, now the state needs to make the second sounds, the gunshots, but then of course, in the same process, must ignore the first sounds and must ignore the cricket bat sounds, because then there's no space for them and there's no explanation for them. And they say, but we can help you. We can prove that the second sounds, by ignoring an explanation for the first sounds and the sounds made by the cricket bat, were in fact the shots, because there were 4. Mrs. Johnson. There were 4. Now let's look at it. Mrs. Berger. There were 4. And she says so well, I had music as a child. I've got a musical talent. I can hear ta-tum, 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 ta-tum. I cannot make a mistake. You, of course, take that evidence for a moment. You move away and they say, well, let's look at the other ear witnesses. How many shots did Dr. Stipp hear? 3. How many cricket bat shots? 3. How many shots, the second shot sounds? How many shots did Mrs. Stipp hear? 3. The cricket bats struck 3 times. Mr. Johnson can't help us. A volley. Can't help us. A volley of shots, maybe 5 to 6. Didn't know. A volley of shots. He says, I can't help you. So he doesn't help us. And then, my lady, it's the only remaining witness on the 4 shots at a time when it could not be the shots, because you need then to ignore the first sounds on the cricket bat. Then comes the revelation. The notes, edited and edited again by Mr. Johnson. What did Mrs. Berger say? How many shots did she hear? 4 to 5 shots. 4 to 5 shots. How's that? What has happened to the exact 4 shots corroborated and by this musical ear? What has happened to the exact 4 shots, and where does it come from? Where does this exact absolute 4 shots come from when you look at the notes that Mr. Johnson kept on telling us? They are accurate. I stand by them. When he was crossing, he said, I want to look at my notes because they're accurate. Can I just refresh my memory? 4 to 5 shots. That question mark of uncertainty. Why did she not tell him? I have a musical ear. Not 4 to 5. 4. So it's not true. It's not true. That's exactly at 4 shots. We know we can go to when the event was fresh in the memory. 4 to 5 shots.
You're talking about the notes that were taken by Mr. Johnson.
Yes. And he says that his wife agreed with it. Mr. Nel was trying to say, no, she agreed on a version. That's not what he says.
Hold on. Ms. Berger agreed. Wasn't the evidence that Mr. Johnson did not even show the notes to the wife?
Yes, my lady, but that does not help. That's what he says later on. But you just have to read the last paragraph of Exhibit N. It makes simple reading. You just have to read it. But even if you don't read it, then you have to ask him, where does Mr. Johnson get the 4 to 5 shots? Because they discussed the matter, they spoke to friends.
Yes, but you can't be certain that he's the one who's correct.
Well, my
or
lady,
vice versa.
My lady, then let's do that. It can be that it's right. It can be that it's wrong. It can be that Mr. Berger is right, and it can be that she's wrong.
Yeah.
That would be neutral.
Yes.
And that tells, and I agree, that would be a neutral approach, and that does one thing.
Yes.
What do? We don't know. But then we look at the other ear witnesses, and we say the accused version 3 times. And then we get Berger and Berger 3 times, 3 times. In a state of alertness, they're worried now. They heard the screaming. They've heard the shots. They alert 3 times. It's not a coincidence. Let's make it easy, my lady, if I may. So when you apply the law and you say, well, what is my finding going to be on that? And I'm going to move to other factors as well, just up to here. I need now to say the state's version that it was 4 shots, and those were the shots. Does that inference exclude other reasonable possibilities on the Blom's approach? And you can't just pick possibilities and put them together. And you say, well, the state doesn't explain to me the first shots. It doesn't explain to me what the sounds of the cricket bat would have been, and we'll deal still with that. There's no time then for that on the state's version. I have 2 witnesses saying 3 shots, exactly accurate with the accused version. And I have a witness saying 4 shots, but her husband tells me that these notes would say 4 to 5, and I have the husband saying only a volley of shots. What do I do with that? I don't know. I cannot, on those facts, bring out a finding to support the state's inference. It is just not possible. We say it's more than that. We say that we've proven the correct position. But even if not, we don't have the onus. We have the circumstantial evidence criteria, and the state's in trouble there. But it goes further than that, my lady. That's not where it stops on what I've said. Let's look I deal with it at page 101. Of the heads. Now let's assume for a moment that the state is correct and forget about its inability to explain the first shots. Forget about its failure to explain the sound made by the cricket bat. And we say they're correct. Let's make the shots, and let's forget about 3-4 volley. Let's look at times. We know it was 3:17 sometime because Mr. Berger phoned 3:16, spoke for 58 seconds, then went up, and then thereafter the shots. So it's 3:17:30, 3:17:20, I don't know. It's slightly after 3:17. And we know the accused made the call at 3:19. So we talk about 1.5 minutes between the state's shots and the phone call. Make it 1 minute 40 seconds, can't be that long. Now we have to try and look at all the actions. Because he shouted, help, help. And in order to hear him, he said he went onto the balcony. That was heard far away by Gerrie's Viljoen. That was supported by Mr. Lynn. Says, yes, it's on the balcony, you would hear it. He had to put on his prosthesis. He had to go back to the bathroom. The footprint is there on the door. Colonel Vermeulen says, well, it was not my mandate to look at that. It was not my mandate. I just want to see if the door was damaged. I didn't look at it. But we let the evidence on the footprint. It's on the door caused by a kick with someone with the prosthesis on. Then you have to go back and get the cricket bat. I eliminate from my example the contentious parts, looking for the deceased, over the bed, behind the curtain. We don't need that in time. Then he must take the bat, go back, break the door. Then he must find the key. Then he must break out the panels, must find the key, unlock the door, take the deceased out. Going to the bedroom where the blood spatter is the cast off, where he fetched his telephone on his bedside table, top on the wall there. Colonel van der Nest say that's the result of cast off. Go back. And then he phoned 319. Mr. Stander, 320 911, 321 security, 321 returned the call, and 322 he went down. So there's no time there. When would he have done between 317 something and 390 all these steps? Impossible. It cannot be. And I was looking in the heads of arguments for state, and I thought to myself, what would they say about this now that they've made the cricket bat sounds, the shots? It cannot be on time. But that's not all, my lady. And we deal with all the steps here. And Colonel Vermeulen, it's there for you to read, and Dr. Versveld, it's not too important, it's all in their heads. We also go to page 109. We've dealt now with who heard what and so on, and why we say it's correct. Let's look at the probabilities. Because that's a wonderful aid in any case, civil and criminal. What we do know, say for Dr. Stipp that we've dealt with, that Mrs. Johnson, Mr. Berger, Ms. Nslingethwa, and Ms. Viljoen, Carice Viljoen, in that time period, between the first and the second sounds, they heard a man screaming, shouting, help, help, help. Let's try on probabilities to give it a place in time. Would it make sense, my lady, if the shots were as suggested / submitted by the state, 317, we know it was before 317, that's conclusive. Would it make sense that before firing the shots, that the accused would shout, help, help, help? Or would it make sense that after firing the shots and after realizing it was the deceased, that's his evidence, that he desperately wanted help, that he opened the sliding doors and he shouted for help, heard as far as the house of Mr. Stander? Would that make far better sense? Well, it's not even a comparison. It simply does not make sense that he would scream or shout, help, 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 when he was now in this rage mood. I'm not sure what he was doing, whether he was now standing in front of the door or standing in the entrance and talking to the deceased where she was in the toilet, or whatever the versions. I don't know anymore after the state submissions. But what I do know, on any version and any submission, you don't find a probability that would justify the help, help, help. It goes one step further. The anxious screaming, also by a man, not as if they were fighting. We quote that part. Not as if they were fighting, as if they were being attacked. The anxious screaming also by a man. When would you expect that? When the accused wanted to kill the deceased, anxious screaming coupled with the help, 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 there's no space for that on probability. Or when he found out, when he realized what he had done, would you expect him to scream like that? Oh yes, my lady. And if I may correct the state said that screaming before was He screamed so loud, and why did no one hear him? Before the shots, for the intruders to get out. He screamed as he's never screamed in his life before. Can I correct the statement? He did not. The part where he said he screamed like he's never screamed before in his life was in relation to after the shots. That is when he said it. The first screaming was directed at people in the house, not to call help in from neighbors and people in the neighborhood. The second scream, and we can understand that it would not have been heard. People were sleeping. Van der Merwe was some distance away in the opposite direction. We understand that part, that she didn't hear it. We understand the Stips were sleeping. Mrs. Stip was awake, but with a bout of coughing. Getting up. Mr. Johnson was sleeping. Mrs. Berger was sleeping. They didn't even hear the first shots. So we say that on probabilities, that's when you would expect it. It does not make sense on the state's interpretation. Now, of course, if you take that then and say we have no explanation coming from the state, the first shots heard, no explanation why the cricket bat, when the cricket bat hit, no explanation for the insufficient time then to have made the call and to take all the steps, no explanation why someone would desperately scream help, help, help and scream anxiously, a man. There's no explanation for it. And then you just add to it and saying, what do we now do with Mrs. Stipp's evidence that about 3:15 the accused was seen walking in the bathroom through the top half, only be with his prosthesis on, when it's common cause that he fired the shots on his stumps. And you say, well, when did he fire the shots? About 3:12. When did he put his stumps on? Look at his evidence. He says, it is in that period that I put my legs on. My legs on when I realized. It makes perfect sense. There's no mosaic crumbling and falling, and there's no dropping of the baton. That's so eloquently put by Mr. It's not there. It makes sense. It slots in. Everything just slots in. Now, my lady, if I forget about all the submissions and saying what we've in fact proved to you when the first shots were and when the cricket bat sounds were, again, and that's also for Mielen's evidence, subsequent to the shots, the door was damaged. Objective fact. Then we say, let's ask a legal question to you, my lady. That the state proved to you that the only reasonable inference is that the shots were 3:17 and that inference excludes all other reasonable inferences. You have to ignore all these probabilities and all these objective facts to do that. We say, never ever. It cannot be. It cannot be. And that's the difficulty in the state's case. So it takes us, my lady, to the screaming. And I've really dealt with that. What we say to you, there's a whole Annexure C, setting out in detail that what was heard was at the same time, and we get blamed and say, why did you not call your expert? He screams like a woman. My lady, may I explain this? What the state did to us? He kept the state witnesses not to be called by the state back until the close. This is right. But this was the effect. Until the closure of the state's case. So when we cross-examined the state witnesses, we were dependent on an expert to help us, in addition to Mr. Lynn's evidence. But it's never good to have an expert in the face of ear witnesses, if there's such a thing. And we didn't know, because there were short statements by Mr. Nslengethwa, Mrs. Nslengethwa, and a half a paragraph statement by Mrs. Motswane. We had no clue what they could tell us. And then, when they became available, we consulted and we said, but hang on. There it is. No woman screaming. Man in a high-pitched voice. And we took a decision. We have now witnesses. Our dependence on experts have fallen away. We have now the immediate neighbors. And we say, why did the state not call them? We understand now. Because they destroy or refute or contradict the evidence called by the state. I understand that. That part I understand. But they were there. And unless the court's finding that they were hopeless witnesses, they won't even cross-examined thoroughly by the state. Not at all. You can go through the record. They were there. All we had to do was to prove that it was the same time with the screaming. All we had to do, and that we did in the timeline. Once we did that, it was bingo. Once we did that, it was the end of that aspect. As a precautionary, to assist the court in that sense, we decided to call an acoustic person, Mr. Lynn. Mr. Lynn really was objective. He didn't try to say things that could not be. He was down the middle. But he said two things that are absolutely important, my lady. The one is he's simply warning. He says, be careful. When you think that you can discern between the scream of a man and a woman, you can, but it's risky. There is a risk factor. That's all he says. There is you can absolutely, when you hear no, it's a man, and absolutely, when you hear no, it's a woman. He says, there's a risk factor. Excuse me, my lady. But he says a second thing that's far, far, far more important, my lady, learned assessors. He says this. He says, if the person who was screaming was in the toilet, then I can tell you one thing. In the bedroom of Mrs. Berger, it's extremely unlikely to be audible and definitely not intelligible, meaning you can discern male, female emotion. He says, there's no chance. Even if you add that 10 dBA, he says, look at it. It cannot be. I forget that there were dogs barking because that would further complicate. And in court, he said, let me demonstrate to the court what the 40 dBA is. We all had to keep quiet. There was just some people typing and the recording machines. That was 40 dBA. He says, it cannot be. What does that mean? Then it started to make sense in two ways. The one is Mrs. Berger's evidence that you could hear the screaming in the bedroom, the emotional screaming, discern it, compared to her husband, which said, I lifted my head to make sure and I decided to go outside. It was not clear in the bedroom. He had to go to the balcony. That, plus, more importantly, my lady, more importantly, we know that the screaming heard by Mrs. Berger, was the same time as the screaming heard by the immediate neighbors and by the Stips and by her husband. If she heard emotion, if she was truthful, And if she could hear a man screaming and a woman, if she could discern, if she was truthful, that screaming could not have been from the toilet. That's Mr. Lind's evidence. That's a definite. Could not have been from the toilet. Then it must have been from outside the toilet. Who was outside the toilet, my lady? The accused. The accused. And then his risk factor saying, be careful to distinguish. To think that it's clear, the distinction between man and woman. There's a risk. But more importantly, then the contradiction between the immediate neighbor's evidence and the other evidence. That contradiction becomes pertinent. Because it supports now, the acoustic evidence supports the accused version. He says, that's when you would hear it. And he gives the DBA. He says, yes. If it was from the balcony or from the bathroom, not in the toilet, you would hear it. But not from inside the toilet. Now, unless it's a different screaming heard by Mrs. Berger, that can't be. It was the same time. So that's the value of the acoustic evidence. Those 2 points. You say, if it was a screaming from the toilet, you would not have been able to discern that screaming in the bedroom of Mrs. Berger. And Mrs. Berger never went outside. She remained in the bedroom. Now, if you add that factor also to your question, say, as a court now, what must the court do? How do I find that the only reasonable inference, excluding all other reasonable inferences, is that the shots were 317? In the face of all these factors, it cannot be. The only solution the state has to say Sol's case, and please go and read Sol's case, my lady, to say, well, you don't have to prove everything, you must put them together. We agree. But at least what you cannot do is to say, well, he raised a possibility, not a good one, but there's a slight possibility that it could have been an argument. There's a slight possibility it could be a woman screaming. There's a slight possibility, I'm coming to that she could have eaten. I take now the 3 slight possibilities and I come to a conclusion. That you cannot do. Although you consider the evidence in the context of everything, you have to look at material facts and determine for yourself if you can rely on that fact. And if you can't just keep it in the loop. You have to determine if that's reliable, particularly where that fact offends or that evidence offends objective facts. My lady, that brings us to the eating. I call it dinner for short. The dinner, that's page 36. Now you would see in the heads of argument, my lady, we deal with it from pages 36 to 53 in detail. But if I may sum up. Let's start at page 36 and first see, before we get there, what the state was submitting to you. State says the best ever witness is Professor Simon. He's a highly qualified, good person. You're not always right when you're that. And in many respects, he was a brilliant witness. But we're going to deal with some of the aspects. And he says, on Professor Simon's evidence, she must have eaten 2 hours, the deceased, 2 hours before death. That was the last food intake, which is about 1 o'clock, 1:15. That we understand. That was his evidence according to the state. That's not his evidence. I will come back to this. His evidence is rather this. I will suggest that it was about 2 hours before the time, but I must tell the court there could be an hour or two variation on my estimation. So on his evidence, first, leave it untouched. We know she could have eaten, according to him, because of the sole fact of stomach content, any time from 11 o'clock that evening to 1:15. Any time from there. That's his evidence, not 1 o'clock. He only says, I suggest. We quote him. We use his language. And he's at pains, and I know Professor Simon like that, to say, but my lady, this is not an exact science. It depends on many factors that we don't have. I only have one in my experience. But I only had one, I saw the stomach contents. I don't know what she had to eat. I don't know the right time what she eat. I don't know the volume. I don't know her condition. It's not exact. But I would suggest, in my experience, that's what I would say. That's his honest opinion. So we know, on his opinion, it's not from 1 o'clock at 1 o'clock. It's any time from 11 o'clock was the last food intake. He's not saying that, of course not, that the accused was also eating. He's not saying that both of them were awake. He's only saying that. But let's now look how this piece of evidence developed with respect in the state's case. In the further particulars, my lady, and we deal with that at page 36, paragraph 102. The state told us, and I quote, the deceased had something to eat hours before she was killed. That's the state's case. So something happened to change that. If we look at Professor Simon's post-mortem, we don't find that something. I will invite you, my lady, to go through his post-mortem report. There is not a single piece of evidence dealing with last food intake. It's not there. It doesn't deal with it. Professor Simon knows. If at the post-mortem you entertain that idea, he knows what to do. It's in the evidence. You open the duodenum. That's one of the crucial aspects. He didn't. There's only one reason. He's a thorough person. Why he did not. That was when he saw the stomach content. That was not what he thought at the time. When the state furnished their further particulars, that's not what they thought. Subsequently, they looked at it and said, well, maybe there's something in this point. It's a point that developed. So we know now, take that point that was not dealt with in a post-mortem, and know now there was, on Professor Simon's evidence, a probability, not beyond a reasonable doubt, that she could have eaten any time from 11 o'clock that night. Now, let's test that, my lady. And we do this at page 38 of our heads of argument. Let's look at the real evidence. And let me immediately say something. I don't know. I don't know if the deceased, when the accused was sleeping, felt hungry for something and had something to eat. Because I don't know. The state says the alarm was not activated, then it was activated. And she stayed in that house before. She was that afternoon in that house. So we can't say that she didn't have a clue about the alarm system. I don't know that. So I can't exclude that. It's open. Of course, in that respect, the accused might have had something to eat. But that doesn't assist the state. Because that does not mean that they were sitting down, as suggested by the state, in the kitchen and having dinner at 1 o'clock in the morning. And then started to fight, and which led to this. I simply don't know that factor. And I've given it a lot of thought, my lady. I just don't know. That's a possibility. But what I do know is if I leave that aside for the moment and I look at the objective facts and I say, let's just test probabilities. And again, with that one point, that's still hanging there because that point does not offend probabilities that I'm going to give to you. Let's look at the accused. He came home, unchallenged, about 6 o'clock. The deceased was busy preparing food, stir-fried chicken. That we know. He says between 7 and 8, we had dinner. We know one thing, he was absolutely active on these electronic equipments, the iPad and whatever. We know one thing, unchallenged. Between 10 past 7 and 8 o'clock, no activity. No activity on his iPad. And he explains that. He says we were talking about a contract, a model contract and so on. We were eating. It makes perfect sense, logic. Logically, it makes absolute sense. There's the food. And he says then we went to the bedroom. She brought us some coffee. We see the two mugs on the bedside tables. And I slept, and she, don't know when she went to bed, but it was sometimes later I asked her to close the door and bring the fans in. That we know. And is that objective support, the lull, the stop in the iPad activities. Now, let's not forget that as court officials we're also human beings. And that we understand logic to some extent. And we have to ask ourselves, because logic would always make sense with probabilities. And we say, here you have an athlete and a model. Food's ready at 7 o'clock. They would now, for some reason, decide to go to the bedroom without eating, then wake up at either 11 o'clock at night or at 1 o'clock at night, state's version 1 o'clock because he forgot about the variation. Go down to the kitchen because we know no plates, no cutlery, no crockery in the bedroom, but for the mugs. And go and decide we are now going to eat. I was not in the mood to eat, and you were not in the mood. A model and an athlete would not eat, but would wait till 1 o'clock in the morning on the state's version to go down to the kitchen and have dinner now. It does not make sense. It does not explain the open period on the iPad. It does not explain common sense. It simply does not make sense at all. Of course, I again say it does not offend that she could have come down, unbeknown to the accused. She may have come down because you feel peckish later at night. Some of us have that habit, some not. I don't know if it's so. So, we say it simply does not make sense. Then we look at the evidence of Professor Simon. And he tells us that. We start with that, my lady. It's there for your careful consideration. Starting at page 40, where he says, I would suggest, he's very accurate, Professor Simon. He says, I would suggest it would have been 1 o'clock. But he says, my lady, that's page 42, that he could only provide a probable, I quote, it's paragraph 126. I can only provide a probable time frame. And he prefaced that by saying that it probably can vary by an hour or two in either direction. That part the state just ignored. Then he goes down on 128. He talks about probabilities all the time. That's his view on probabilities. He's an honest person. I can never and will never in my life make a submission that Professor Simon is not an honest person. But that's a view expressed by him. And he warns us to say, That's my view, but that's what I suggest. It's probabilities. That's my experience. I look at it. But it can vary. It can be 2 hours earlier. Then we say, but we know the test. You have to look, and the law is quite clear. It says when you have expert evidence, and it contradicts eyewitnesses, unless you find an eyewitness account to be false, you have to give preference to an eyewitness. We often see it in motor car accidents, where you get the reconstructions, and when it is not consistent with the eyewitness account, you cannot take it into account. When you have to make a choice, you have to give preference to an eyewitness account unless there are reasons for you not to do so. But then, my lady says, but remember that it doesn't stop. The digestive process does not stop. It carries on post-mortem, after death. Now we know that the refrigeration was only after 10 hours. Now if that is true, and if it was a normal process that would accord with probabilities, everything, there would not have been recognizable food in the stomach. The enzymes would have digested that, would have changed it. So his own evidence tells you. That's maybe the general rule, but it does not work like that. And here we have the absolute example. Why was he, after more than 10 hours, could he still recognize food particles and say what it was, vegetables? If on his own evidence, the enzymes would have caused the further digestion because he does not. And that is what Professor Lundgren was saying. On Professor Simon's evidence, it does not make sense that you could see it, and that shows, she says, that shows my point. It is unpredictable. You have the general rule, but it's unpredictable. Let me share with you, she said anecdotally, my patient, a light meal, toast and tea, 8 hours later, stomach content. 8 hours later, she says it's not to be expected. It's not a hard and fast rule. You cannot say. This is a general rule, nil per mouth for 6 hours. And that's not the only case. There were many such cases, she said. That's not the only case. So it tells us, yes, on probability, understand Professor Simon's evidence. But also, please understand, my lady, what Professor Lundgren was saying. She works with that. That's her practice. She says that is the difficulty. You cannot say it so. I can't say Professor Simon is wrong, but I can say be careful, because this is not what we see in practice. And that's all Professor Botha was also saying. He referred you to Bernard Knight and other articles to say it's too risky to say. Professor Simon may of course be correct, but he may of course be wrong. The probabilities would dictate to Professor Simon that's the position. But is that so? Can you take that as a fact and say, I find now as a fact that she ate 1 o'clock in the morning? No, my lady. You cannot. Professor Lundgren explained that from the beginning end, and Professor Simon warned against us. He says, that's why I suggested on my experience, but that was a single factor that I looked at. Professor Botha explained why you must be careful to do it. Do I say that she did not eat at about 11 o'clock? No. I don't know if she went down. But do I say, and do we submit to you, that on all the evidence, and we summed it up, that you can accept the fact, to say, I'm going to hold this against the accused as the only reasonable inference, excluding all other inferences, that she was awake, and therefore you argued. She was awake, she in fact ate. had food intake at 1 o'clock in the morning. I'm going to forget the 11 o'clock because that doesn't assist the state. And that they sat down in the kitchen downstairs 7 hours after preparing the food, deciding now we're going to eat cold food for the first time. Is that the only reasonable inference? It cannot be, my lady. It cannot be. I'm not attacking Professor Simon's credibility. Not at all. I'm just qualifying the whole situation.
I think you've made your point.
Thank you, my lady. I thought I was good to the man to repeat that, Madam. My lady, I see it's 7 minutes. I've got a bit of a throat problem. I'm keeping my eye really on the time.
Yes.
Would it be an opportune time?
You want us to adjourn? Yes, we'll take our adjournment. We'll be back at 1:30.
At 1:30.
1:30.
Thank you, my lady.
Ariel, buiten Deutschland.